kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. That him, he Anglican, please, Verbus Latin.
Is that correct?
I didn't ask you to interrupt me.
Literally not true.
Oh, for crumb's sake.
Good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Tuesday to you. We've got a lot of fun stuff to do, and one we're going to jump to in just a minute. So we've got to get the morning things out of the way. Not that we're trying to get them out of the way. I mean, birthdays are important, but we're going to have to do it quickly. So, good morning, everyone. Good morning. Hope you slept well. Hope you're ready for a big, great day of court watching. I think we've got a little case hearing going on right now that I'm very intrigued with. I want to jump to. So. Thank you, Josh, by the way, for the update. All right. We're ready for the next music. We're ready for birthdays already. What do you think? How are your hands doing? Better? No, worse. No, I've now got some blisters that I didn't have before, and a few more, like, what are they called? Filament slivers under my fingernails and everything else. I printed an ocarina for my son. Which is like a little. If you ever played Legend of Zelda on the computer or a Nintendo or whatever it was, it's the little weird flute he plays. It's a little gourd-shaped flute. I made one of those on the 3D printer yesterday, and of course, it required lots of digging out all the support filament so that it doesn't collapse on itself while it's printing. And yeah, I'm still learning how to do this. All right, we're gonna sing "Happy Birthday" to Kate, and Priscilla. Kate, and Priscilla are the two birthdays, and it's going to have to go fast. So everyone, stand up wherever you are, deep breath, shoulders back, project your voice to the back of the room, blend your voice to the neighbor, and warm up with me if you will. La 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 la. Not on screen. I'm not on screen. All these problems, we'll get them fixed. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Kate and Priscilla. Happy birthday to you. Kate and Priscilla, there are many wonderful days. Today is your special day. And I realize there are a million places you could be and a million people you could have spent today with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can turn that joy back to you, make your day a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Happy birthday, you look good. Yes. All right, I'm not sure if we can make it all the way through the dancers. We've got to jump to this. I'm worried it's going to disappear. I'm worried. I have the worries. Oops, my tool's not working here. Oh, by the way, my thumb hurts really bad. Like really, really bad. I think I bruised the bone by stabbing it with a round object. So I've got like a tiny, it's not really a puncture hole. Barely broke the skin, but it pushed through the muscle all the way to the bone. Yeah. What does New Year's Adam mean in the title? Well, you've got New Year's Adam and then New Year's Eve and then New Year's Day. I think that's the order it goes in. I think it's New Year's Adam today. Danny Austin, unfortunately stuck in my leotard from yesterday. Just keep dancing, Danny. Just keep dancing. I suggest you're doing it wrong if you're greeners. Possibly. Luckily, I can still play the air drums. All right, welcome. I have to also say Stephanie, just Stephanie W. Welcome. Congratulations. Good morning. You were here first. You talked in chat before anybody else. Because of your promptness and your punctuality, we're going to punish you with the internet. We're punishing you with the internet. The whole thing. We're giving it to you on your shoulders. Your job to maintain it, keep it up, fix it, train everybody how to use it. Everything. It falls on you. So congratulations. You are our internet winner today, which is, I guess, not a good thing. All right, let's jump to this court in Michigan where we have a hearing underway. Let's see if we can get some audio here working. Where are we at, Judge? Can you hear me now? This is Dale Warner is accused of murder. His wife. Her body was found in a fertilizer tank on his farm in 2024. This is a pretrial hearing, and it gets spicy with the facts. This is his attorney who just jumped on screen there. Mary Chartier. Let me show you her face there. And as soon as we get the jail in here, we'll have the 4 people needed to proceed.
Okay, good morning. We're just waiting for the jail to get Mr. Warner into a Zoom pod.
Is murder the bad one? It's one of the bad ones. Yes.
Great, thank you, Your Honor.
Oh.
There we are.
Looks like I have to be somewhere else because the attorney has taken my spot. Where am I going to be? Where to go?
Okay, this is file 24-21841-FC, People of the State of Michigan versus Dale Warner. We are here today for hearings on several motions. We are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Wise.
Good morning, Your Honor. Jackie Wise on behalf of the people.
Good morning, Your Honor. Mary Chartier on behalf of Dale Warner, who is participating via Zoom, as am I.
All right, and as I indicated, we do have several motions today, one from the people and several from the defense. So let's start with the people's motion to compel discovery.
Your Honor, I received a witness list from defense last Monday, and I did send a follow-up email requesting contact information from 3 people. And I know Ms. Chartier said she would get that to me. So I expect that to be coming. Other than that, I believe I have what I need from Ms. Chartier.
I love the number 1 hand drawn behind the defendant.
It sounds to me that
with a Sharpie.
You don't feel any.
You don't need any more.
At this point is necessary. Is that
I would just ask Ms. Chartier to confirm that she is going to be sending me that contact information.
I will definitely this week. So Ms. Wise requested the contact information to a paralegal. She emailed the paralegal who had emailed the witness list to her. Because of the holidays, she's been out. I have not had a chance to check her email yet today, just because the hearing started at 8 a.m., but I will. If I don't get it to Ms. Wise today, I should be getting it to her tomorrow. But I don't see any reason why I can't get the phone numbers to her today.
Then I'm satisfied, Your Honor.
okay? All right, that leaves us then with the defense motions. Ms. Chartier, I'll let you start wherever you would prefer.
Okay, here we go.
Thank you. So we filed 4. I won't be repetitive of what's in the brief. I'll just hit some of the highlights. So the first one is the motion for additional peremptory challenges. As this court is aware, there are 12 each that each side will get because this is a life offense. When courts have granted this in the past, while courts have the discretion to only give one side additional peremptories, if this court were inclined to give the defense additional peremptories, we certainly don't object if the government would seek more as well. The good cause here, which is required under the statute, quite frankly, is the significant media coverage as well as the significant community opinion that appears to exist to a large part to Mr. Warner's detriment. So I know when we brought the motion for a change of venue, we articulated that in the Justice for D page, there had been communications or posts about being a stealth juror, and that's still our concern. The concern is that people will say the right things in order to at least be able to be seated on the jury. And as this court knows, it's not only about what people say, but it's also about how people say it. So someone may say, well, yes, I had this opinion, but I can be fair and impartial. That's really not enough to be a seated juror in this case. And while that may not rise to the level of cause, depending on what the court's determination is, it certainly would indicate a need for a peremptory challenge to
We're
us.
getting
And
close. I
obviously,
don't have the
each
dates
juror
yet.
is an individual, and we would certainly delve into what they have to say, what their thoughts and opinions are. But my concern is that people may say the right things to be seated, and then with only 12 peremptories, we cannot protect Mr. Warner's constitutional rights.
People will lie to be on the jury, is what you just said.
Your Honor, this court, I believe, has set it up for approximately 700 potential jurors to be brought in and has allowed for
700.
individual juror questioning. I believe it's up to the parties in the court to determine, yes, while some jurors may say that they are able to be fair and impartial, I believe that further questioning will get us to whether they can actually be fair and impartial. And I believe the court has enough things in play to weed out those jurors. So I would ask the court to deny this motion at this time.
Ms. Shardy, I'll give you an opportunity at rebuttal if you care for it.
The only thing I would ask is if the court is inclined to deny the motion, I would ask the court to deny it without prejudice so that if the need comes up during jury selection, we can renew that request with the court. And I'll be frank, a lot of it depends on some judges are much more strict with challenges for cause than others. And so a lot of it depends on where we land with that during jury selection.
Where you
We've
are,
had
Judge.
additional peremptories before, and we haven't had the need to use them because courts have been more liberal with challenges for cause and vice versa. So if the court is inclined to deny, I would just ask it to be without prejudice so we can renew. Thank you.
Okay, it is clear that there has been a large amount of media and social media coverage and interest in this case. That has been the topic of prior hearings. In response to that, the court has called in a significantly larger number of jurors than it would normally call in, even for a capital case. I think that additional number of jurors
Is sufficient.
in my mind supports the increase in peremptory challenges. I do think there's a concern here that first, that we're likely to excuse a large number of jurors for cause, but there has been some indication that there are some people who may be interested in trying to get on the jury when they shouldn't be. That social media post has previously been
Argued.
provided to the court, and I think we need to take that concern seriously. I do think that supports a finding of good cause to increase the number of peremptory challenges in this case. And as I said, I'm more comfortable doing that given that we have a significantly larger normal number of jurors that will be in the pool. So at this point, I would grant that motion and increase the number of peremptory challenges for each side to 18 from the 12 that they would normally get, so a 50% increase.
That's a big bump.
In peremptory challenges.
Thank you, Your Honor.
All right, which motion would you like to address next?
The jail calls, please.
Okay, this is where it gets this. I just heard
So,
a tiny bit of this. Listen.
I'll wait till the court's ready. Sorry.
Go ahead.
Okay. So the court is well aware that we had filed a motion to preclude the use of 2 jail calls or any other jail calls that the government sought to admit, and the court denied that. The court did grant our request for all of Mr. Warner's jail calls to be sent to us. We have gone through those, and I will tell you I was surprised when I was listening to one and I heard voices familiar, and then I realized it's my voice, Mr. Head's voice, voices from our office, voices from the Head Murphy law firm. And as I went through, I thought, well, maybe that was just a mistake. Someone happened to record that by mistake, and it wasn't a mistake. Then when we had the hearing the last time in court, Detective Drurior admitted that he is listening to attorney-client phone calls on the jail line. And that was extremely surprising to me, because when there's a wiretap, for instance, in federal court, you frequently will have wiretaps on clients' phones. The order always indicates to not listen to privileged calls. And so when you get the calls from the government where they're wiretapping your client's telephone calls, when you get a privileged call, either with a doctor or more frequently with their lawyers, you'll hear it say minimize. And then the rest of the call was never listened to. It was never recorded. Here, not only were the calls recorded by the jail, but then they were turned over to the police, and then they listened to all of them with no attempt, according to Detective Drury, or to stop listening once they realized they were attorney-client calls. He indicated he was on the treadmill, and then he just kept listening. And some of those calls go 12, 15, 20 minutes long. It was shocking to me how nonchalant he was about listening to attorney-client communications between Mr. Warner and myself and the Head Murphy law firm. He's working out. It's not like he's bedridden. He could have jumped off the treadmill and moved on to the next call. He chose not to do that. And then I was even more surprised, quite frankly, when I got the prosecutor's response that they don't think there's anything wrong with that. And presumably those calls have been turned over to the prosecutor. I was actually operating, probably mistakenly, under the assumption that those calls were not turned over to the prosecutor, but based on their response, they very well may be. So for the number of years, essentially, or certainly significant number of months that Mr. Warner has been locked up, people have been listening to his attorney-client calls. I mean, it has an unbelievable chilling effect. Mr. Warner called our office. I said, tell him I'm not going to take the call. I'll visit with him instead. But then I'm quite frankly concerned about, if I do a video visit with him, are they now recording that and turning that over? If I meet with him in person, is someone flipping a switch and listening to the communication? The lack of concern for respecting privilege is quite frankly chilling. But what's even more concerning is the prosecutor just going along with that. If the jail records the calls, I don't think they should. But regardless of that, even if they do, once the police know that they are listening to an attorney-client call, they should stop listening, not just double down, listen to it, and proudly state on the stand that they are listening to it. I struggled with, quite frankly, what's the remedy here? I've never had this happen in all my years. I do know colleagues around the country who've had this happen, but I always thought, well, that's such an anomaly. I can't imagine anyone in Michigan who I've ever worked with doing that. Well, now I certainly can imagine that because it's happened to Mr. Warner. What is the remedy here? I mean, the remedy at a minimum is an order saying stop listening to Mr. Warner's attorney-client calls. But does that go far enough? I leave it to the court's discretion. I mean, remedies can range from dismissal of the charges to sanctions to jury instructions. The damage, though, is done here. So it's so difficult to fashion a remedy to talk about you should never have been listening to his attorney-client calls from the beginning, which is such a basic concept that, quite frankly, I was shocked I had to file the motion, and then I was shocked at the response that I received.
State.
Your Honor, in this case, the attorney has the ability to go to the jail and meet with her client. She has the ability to set up her phone number with the jail to have that protected conversation. But to say that she's shocked by the fact that they were being recorded, I have never listened to any of her attorney calls. Nobody's ever called me and said, oh, guess what he was talking about with his attorney. So before this motion was brought, when Ms. Chartier brought it up with me, I didn't know these were being recorded. However, after I got this motion and researched this, I went back and listened for numbers that I didn't recognize. One of the calls, all of the calls say, this is a free call from Dale, an inmate at the Lenawee County Jail. To accept this call, press 0. To refuse the call, hang up or press 1. This call is from a correction facility and is subject to monitoring and recording. Thank you for using GTL. On one of those calls with the number I didn't recognize, as soon as the called party answered, Ms. Chartier responds, Dale, hi. So to say she had no notice that those calls were being recorded is without merit, Your Honor. And the case law is very specific that this is not a confidential communication when they waive the privilege based on that message that was on the phone.
Ms. Shardy?
Thank you. So I spoke to Mr. Warner. He indicates that there is not an option for him at the jail to segregate out attorney-client privileged calls. Yes, it says the call is recorded. Obviously, now Ms. Wise has listened to my calls if she knows I say, "Hi, Dale," on it. Whether the jail records the call for security purposes, which the court has already deemed that they can, but then the police and prosecutor listen to those calls are two separate things. There is no security interest for the police to listen to Dale Warner's calls with his lawyers. And I would ask at a minimum for an order telling them to stop doing it. Yes, we can go visit our client in jail, but they also have phones for a reason. And the hours where we can visit our client are restricted because of what the jail has to accomplish. No one is complaining about that. Jails have restricted hours all the time. But sometimes you need to communicate with your client via phone. And the fact that the government thinks that the police can listen to it at will is extremely concerning.
Mr. Fiddle, I'm so sorry you've been in the hospital. Glad you're back home. There's no better place to be than home after you've been in the hospital.
So, Ms. Wise, there is a method by which Ms. Chartier could have her calls not be recorded by the jail.
Absolutely. I confirmed that with the jail captain when I received this motion.
And how would she go about, or Mr. Warner go about doing that?
They need to get with somebody at the jail, a jail sergeant, the lieutenant, the captain, and provide that attorney phone number that they have to exclude from those phone calls. They have to confirm that that's an attorney. Then they provide it to the GTL, which will then exclude it from any of those recorded conversations.
Wow.
All right.
Who is the Mask? Who is the jail captain? Because when I spoke to Mr. Warner, I had asked him that specific question, and he had indicated that there was no method for him to segregate out attorney phone numbers. Some jails have that method, other jails don't. It generally comes from the client, and then it's confirmed with the law firm. So Mr. Warner said that that was not an option. If it is an option, I'd like to make sure I know who is indicated that it is an option. So may I ask who the jail captain is who you spoke with?
Absolutely. Captain Randy Casey.
Okay, thank you.
All right. With respect to any request for a remedy or having listened to calls,
protected calls
up until today, I think that the case law is clear and that it supports Ms. Wise's position. The people have cited to an unpublished case of People versus Miller. I do recognize that it is unpublished and therefore it's not precedentially binding upon this court. However, I do find the logic in that case to be sound and compelling. I think it appropriately states the law, and it is based on People versus Campo, which is a published case by the Michigan Court of Appeals.
Remind me never to go to Michigan.
Sets forth the same principle in a slightly different context, and that is that where a person knows that other people are listening to a conversation, they have waived the attorney-client privilege, and I think that is what has happened here. There doesn't seem to be any dispute that the calls between Mr. Warner and his attorney came with a recorded message at the beginning of each and every call that advised both sides in that call that the call was being recorded, and so that other people were listening in. Having proceeded with the call after that, the confidentiality at that point has been waived, and there's no violation by the people listening to that call. Because again, the element of confidentiality does not exist in that context. So I would deny that motion. However, I do think we have established a process by which Ms. Chartier and Mr. Warner can communicate by telephone. without having calls recorded and have an expectation of confidentiality in those calls going forward.
This is so bad.
Thank you, Your Honor.
The U.S. Supreme Court will have to correct that if Michigan's laws are that way. That is just a bad deal. I think the protection should exist.
Okay, and which motion would you like to
Period.
move next?
Not
The
like-
Daubert
if
motion
you-
on Michelle Ponchke,
If you
who
jump
is
to the hoops, then
paint
we'll give you
analyst.
protection.
All right, go ahead.
Thank you. This court is well aware, I believe, of the standard required
Creamers.
by Daubert. So essentially, the testimony of the proposed expert witness must be relevant. It also must be scientifically valid. And in Craig versus Oakwood Hospital from the Michigan Supreme Court, there has to be a general acknowledgement of the legitimacy of the testing. The testing has to be grounded in scientific principles and methodologies, and the validity of the testing cannot be based on a subjective belief or unsupported speculation. And essentially, it has to be reliable. The burden of proof rests on the government to prove that it is admissible, and the expert, through the government, has to establish the reliability of the principles and methods to draw a conclusion regarding the particular matter to which the expert testimony was directly relevant. In Gilbert, which is another Michigan Supreme Court case, the court laid out 4 separate criteria, and we have none of it in this case. The data underlying the expert's testimony must be substantial and trustworthy. We don't know that in this paint analysis. The manner in which the expert interprets and extrapolates from the data is reasonable and sound. We don't know that. The opinions based on the data express conclusions reached through reliable principles and methodologies. We don't know that. And the expert is qualified to provide opinions that are in the scope of the individual's expertise. We don't know that. We don't even know what her credentials are to examine paint. So we don't have any of the underlying foundation to even let in testimony about paint analysis. But even beyond that, when we get to the relevancy of it, the lab analyst is essentially saying, well, we looked at some paint on Mr. Warner's property. Some of the samples match, some of the samples don't. It could have come from the paint on the property, or it might not have. And then to put it in a context which the court knows, they're analyzing the upper layer of the paint on the tank where Ms. Warner's body was found. So the conclusion of the analyst is it could have come from the same source, or it could have come from a different source. That's certainly not relevant, because an individual source can't be determined, or cannot even be determined with any sort of statistical probability, so that we know, okay, how many cans of this paint are actually produced in a year? How many of it are sold in Michigan? Is this common on farms? It sure seems like it would be. So for all those reasons, I don't believe that Ms. Ponchke should be allowed to testify, because none of the basis of Daubert has been established here. If the court obviously disagrees with me, then I would ask the court for a Daubert hearing in which we could question Ms. Ponchke, as well the government can put their proofs on, to determine if the science is really valid here and if it was applied reliably to the facts of this case. Now, I recognize we have trial coming up in a month or a little less than that, but there certainly is ample time for a Daubert hearing. I don't think that it would be a lengthy process. We also have the roughly 2 weeks of jury selection if we needed to, try to fit something in there. So I would ask the court to grant my motion. Thank you.
Your Honor, as to the relevance of the testimony about the paint, it is relevant because it goes to means and opportunity. Under People v. Hall 433, Mich. 573, and People v. Houston 261, Mich. 463. Both of those cases involved defendant being arrested, subsequently in possession of a firearm that they weren't able to say was the firearm used in the crime that was committed. However, it was similar in kind to which the crime was committed. And the court said those were admissible because they go to means and opportunity. I've submitted the lab report with my response to the court, so the court can see that, again, some of the paint samples did not match, some of them did. I think that it goes to the weight the jury decides to give it, not to its admissibility. It is relevant. However, if the court would want to grant the Daubert hearing, we would have no objection to holding that hearing.
Quick Daubert hearing, everybody.
Anything else on this one, Ms. Shorty?
No, Your Honor, I say no, and then I keep talking. But the only thing is, I think if the court is not going to exclude, I think a Daubert analysis will get to at least the major concerns that I have, with the exception of the relevancy. But again, we don't even know how the science was conducted here. And so a Daubert hearing will at least help us get there.
So check the calendar.
Okay, the way that the court establishes whether or not an expert can testify in case is to conduct a Daubert hearing. I do think that's completely appropriate in this case before the court makes a decision. So I would ask you to schedule that. Perhaps when we're done here, you can contact Sierra Francis offline. And I think we should have some time available before the trial begins in order to get that done.
Thank you, Your Honor.
Okay, I think that leaves only the motion for a spoliation instruction.
Thank you, Your Honor. I would ask for that instruction to be given based on the testimony of both Detective Drurior and retired Detective Singleton that text messages were destroyed. We know that they did not record every aspect of interviews. We know that they didn't necessarily record even some interviews or conversations they had with people or even log it down. When I was questioning both Detective Drurior and Detective Singleton, their response was, well, we didn't preserve text messages, but we don't know how they got deleted off our phone. It may just be a policy or procedure of MSP where things are deleted a year after they're on the phone, whatever it may be. That seemed questionable to me, but that was their testimony. But then we received typed text messages from the government that Greg Hardy had purportedly given to them. So essentially, rather than taking screenshots of his phone or rather than turning his phone over so that there could be a download, he typed messages during a particular time frame. Not all the messages on his phone, but just the ones during the time frame that he believed that Detective Drurior sent his messages over. When we compared the messages side by side, it was clear that the destruction wasn't based on some policy or procedure that Detective Drurior was unaware of, because there are 3 messages that Greg Hardy turned over that he typed. So purportedly they are real messages that Detective Drurior did not turn over. But the other one that is significant is Detective Drurior had turned over a screenshot of a message exchange between himself and Mr. Hardy. But when Mr. Hardy typed up that same exchange, there were sentences missing. And this would be within the 1-year time frame. So there's literally no reason why that aspect of the message wouldn't have been turned over other than Detective Drurior decided he didn't want to turn it over. He either deleted it from his phone or he just chose not to turn it over. That is bad faith 100%. There is no other way to frame that. It is an intentional withholding of evidence from the defense. And the government's notion through the police seems to be, well, we determine what's of evidentiary value. And so if we don't think it's of evidentiary value, we can destroy it. We can delete it. It doesn't matter. But it's the defense's right to see evidence. It's the defense's right to determine if evidence is valid or not valid. And we cited a quote in there from Jenks versus the United States from the United States Supreme Court, which aptly articulates our position on this, because only the defense is adequately equipped to determine the effective use for purposes of discrediting the government's witness and thereby furthering the accused defense. The defense must initially be entitled to see the discovery requested to determine what use may be made of them. Justice requires no less. So it is not for Detective Drurior to determine, well, these messages don't matter, I'm going to delete them. These messages don't matter, I'm not going to turn them over. He has a job, he swore an oath to turn over evidence. And it's not just his determination of what has evidentiary value. And we know from the messages that were turned over that they do have evidentiary value to the defense. So I would ask for an instruction to be given to the jury, because we cannot argue that the messages were exculpatory that haven't been turned over because we haven't seen them, because they have been destroyed. But we do know that they were intentionally destroyed. And so in that case, we don't have to show bad faith, or excuse me, it is not a matter of good or bad faith, which it is with exculpatory evidence. Here, we have to show bad faith, and I believe that we have by the intentional destruction and by the intentional destruction in omission in this 1 year time period where Greg Hardy has proven that Detective Drurior did not turn over everything that was on his phone. Thank you.
Wow. This one's going to be a doozy of a case. She's fighting like
Sure, the
crazy.
due process clause does not impose an undifferentiated and absolute duty to retain and preserve all material that might be of conceivable evidentiary significance in a particular prosecution. Here, Detectives Dreher and Singleton both testified that it was their common practice and procedure to take those messages that they believed were of evidentiary value, document them, and then delete the messages. Detective Dreher is the one that asked Greg Hardy if he had a copy of their text messages to provide to the defense. That can't be said that Detective Dreher acted in bad faith or that Detective Singleton acted in bad faith. Based on the law that I provided the court, I'd ask the court to deny the motion. Based on the very definition of spoliation, Your Honor, there was no intentional destruction of evidence with the purpose of rendering it inaccessible or useless to the defendant. Therefore, they're not entitled to the spoliation instruction.
So that doesn't seem to match up with the police report that we got in the text messages. So according to the police report, Greg Hardy provides a folder of documents that contain text messages. So there's no indication that that Detective Drurior asked for them. The police report says Greg Hardy called me on 12/5/25. I asked Greg about the documents messages that he provided. He stated he provided the messages for the time frame that were in question and has additional messages on his phone. Greg stated it took great effort to document them and it was not an easy process. And I believe that in another email or text message exchange, Greg Hardy indicates that he's been trying to get in touch with, I believe it's Detective Drurior, but nobody is responding back to him. So the notion that he asked for the messages seems to be belied by the evidence that they've turned over themselves. So again, so this is from Greg Hardy on December 2nd, 2025. It's an email from Greg Hardy to Jackie Wise. I've made a copy of text messages that you had requested previously between Drurior and I for the time period that apparently is in question. I have left numerous messages for you and Lee with no response. Do you want the text messages or not? So Detective Drurior isn't asking for those messages. The prosecutor is. So it's not like Detective Drurior is trying to fix this problem that he created. If anything, the prosecutor is trying to, but then Greg couldn't get a hold of anybody. So he came in with at least partial messages. But the messages show that Detective Drurior intentionally destroyed evidence.
And she's done.
All right, I'll touch on Brady briefly since it was briefed, although I understand the arguments to be that defense is not pursuing a Brady violation at this point. But Brady versus Maryland held that suppression by the prosecution of evidence favorable to an accused upon request violates due process, where the evidence is material either to guilt or punishment, irrespective of bad faith. In order to establish a Brady violation,
this is a murder trial. His wife was found in fertilizer.
Evidence is favorable to
bin pit,
the accused
tank.
when it is either exculpatory or impeaching. In this case, there isn't any evidence that the deleted text messages were either exculpatory or impeaching. And therefore, the defense cannot establish a Brady violation. Arizona versus Youngblood established the rule that where potentially exculpatory evidence is permanently lost, a defendant must show bad faith on the part of the police in order to establish denial of due process. United States Supreme Court in Youngblood indicated an unwillingness to read the fundamental fairness requirement of the due process clause as imposing on the police an undifferentiated and absolute duty to retain and preserve all material that might be of conceivable evidentiary significance in a particular prosecution. Rather, the Supreme Court stated, we think that requiring a defendant to show bad faith on the part of police limits the extent of the police's obligation, both limits the extent of the police's obligation to preserve evidence to reasonable bounds and confines it to cases where the interests of justice require it, i.e. those cases in which the police themselves, by their conduct, indicate that evidence could form a basis for exonerating the defendant. The evidence before the court at this point is that certain text messages between detectives and witnesses were deleted. The officers both testified that they preserved anything that they determined to be of evidentiary value and did not preserve other texts that dealt with things like logistical issues and setting up meetings. They both testified that this was consistent with their training and experience. For example, the deleted text messages referenced in Mr. Warner's motion dealt with contacting the medical examiner's office regarding an update. This appears to be exactly the type of communication that the Youngblood court was referring to in not imposing an undifferentiated and absolute duty to retain and preserve all material that might be of conceivable evidentiary significance. I don't think it's been established here that the deleted text messages are even potentially exculpatory, as both detectives testified that they preserved everything that they believed had any evidentiary value. And there's been no indication that the police, by their conduct, have indicated that the evidence could form a basis for exoneration. Assuming arguendo that the evidence is potentially exculpatory, because some can take a broader view that we can't possibly know what we don't know or what the evidence is. It has not been established that the police acted in bad faith in deleting the text messages. The only evidence that they acted consistent with their training and experience in exercising discretion to preserve the items which they believed had some evidentiary value and not preserving the items which they did not believe had any evidentiary value. And so I don't think that there has been a Youngblood violation either. And so I would deny the motion for the spoliation instruction.
Thank you, Your Honor.
This case has appeal written all over it. These are some...
I believe that's all the motions that we had
optics
on the docket for today, unless I've missed some.
No, there are only two other items, if I may briefly address them. Just updates to the court more than anything else. So the court had requested jury instructions by January 7th. Ms. Wise and I have been communicating. I've sent her information. She sent them to me. We should be able to, I think, probably finalize anything going back and forth. And so the plan is to get those filed no later than Monday. So we would overnight them, and that way the court would have them. And then as it relates to witnesses, we received an amended witness list from the government last night. They took off one witness. We are adding that witness onto our witness list. So we will also overnight a copy of it to the court.
Who could it be?
We had put a general line in our witness list, essentially any witnesses on the government's witness list, but just to make sure it's very clear on who's being called by what party. We'll also make sure we add that to the proposed jury instructions, that we have a nice alphabetical list of the witnesses. So I just wanted to mention those two things. We are working on making sure that we comply with the court scheduling order.
You know it's going to be juicy when the state drops a
in
witness and
addition
defense picks them up.
to emailing your, or I'm sorry, in addition to overnighting your jury instructions, can you email those as a Word document to Sierra so that she can start to put those together?
Yes, I usually do, even if it's not requested, because I think it has to be so much easier than retyping everything. So yes, I will do that.
Okay. All right. Anything else that we need to address, Ms. Wise?
No, Your Honor.
Okay. I do owe you decisions on two motions the court previously heard and took under advisement. And since I have you here today, I think I'll just do that on the record rather than write an opinion. The first of those was the admissibility of some photographs that the court has now had an opportunity to review. Those were challenged by the defense. The first thing the court has to determine is that the photographs are relevant evidence means any evidence having any tendency to make the existence of any factor of consequence to the determination of the actions more probable or less probable than it would be without the evidence, and that comes from MRE 401. The first thing the court has to determine is the materiality of the proposed evidence. In other words, whether the evidence was of consequence to the determination of the action. Materiality does not mean that the evidence must be directed at an element of the crime or applicable offense, but must at least be in issue in the context of the case. In a criminal case, all elements of an offense are in issue when a defendant enters a plea of not guilty, which is the case here. The prosecution, therefore, has the burden of proving every element of the crime beyond a reasonable doubt, regardless of whether the defendant specifically disputes or offers to stipulate to any of those elements. The claim that evidence goes to an undisputed point is inadmissible has also been rejected in criminal cases. For example, People versus Mills, 450 Michigan 61, People versus Neaton, 264 Mich 134, and People versus McPherson, 323 Mich 438. Mr. Warren in this case is charged with open murder and knowingly and intentionally removing, altering, concealing, destroying, or otherwise tampering with evidence. Photograph 1 in this case shows what the body looked like upon arrival to the medical examiner. It was covered in a white bag or tarp that must have been placed there by law enforcement, because it does not appear in the earlier photos when the body was initially discovered. For that reason, I don't think that photograph 1 bears on any fact that is in issue in this matter, and I don't find that photograph 1 is relevant, so I would exclude that one. Photographs 19, 20A, 20B, 2A, and 2B all depict Ms. Warner's body wrapped in a blue tarp as it was discovered and then removed from the tank. 20A and 20B are photos taken at the scene. 2A and 2B are photos taken at the medical examiner's office. Those photos all contain essentially the same information. They depict the state of Ms. Warner's body as it was found. I think these photos speak directly to whether her body, which is evidence in this case, was concealed, altered, or otherwise tampered with, which is an element of the tampering charge. Photographs 3, 4, 5, 6, and 7 depict the state of Ms. Warner's body upon being unwrapped from the blue tarp. They depict additional tape around portions of her body. These again speak directly to whether the body was concealed, altered, or otherwise tampered with, which is an element of the tampering charge. Photographs 8 through 17 depict the injuries that Ms. Warner suffered. That information speaks to the cause of death and to intent, which are both elements of the open murder charge. Therefore, I found those photographs to be material to this case. I'm going to hold off on photograph 18 because I have some additional questions about that. Next, the court has to determine the probative force of the evidence, whether the evidence makes a fact of consequence more or less probable than it would be without the evidence. Any tendency is sufficient probative force. As I've stated, the people must prove beyond a reasonable doubt that Mr. Warner caused the death of Ms. Warner and that Mr. Warner intended to kill Ms. Warner. These pictures, the pictures of her injuries, make it more probable that Ms. Warner was intentionally killed. And so I do think those photos have probative value. People must also prove that Mr. Warner removed, altered, concealed, destroyed, or otherwise tampered with evidence. And as I've said, Ms. Warner's body is evidence in this case. The pictures of where the body was located and the condition upon being found make it more probable that her body was removed, altered, concealed, or otherwise tampered with. And so I do find that the photographs have probative force. In determining that the photographs are relevant under 401, after determining that the photographs are relevant under 401, the next question is whether the evidence must be excluded under 403. Under MRE 403, relevant evidence can be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. All evidence offered by the parties is prejudicial to some extent, but the fear of prejudice does not generally render evidence inadmissible. It's only when that probative value is substantially outweighed by the danger of unfair prejudice that evidence should be excluded. Photographs are not excludable simply because a witness can orally testify about the information contained in the photographs. Photographs may also be used to corroborate a witness's testimony. Finally, gruesomeness alone need not cause exclusion. Photographs that are merely calculated to arouse the sympathies or prejudices of the jury are properly excluded, particularly if they are not substantially necessary or instructive to show material facts or conditions. If photographs which disclose the gruesome aspects of an accident or a crime are not pertinent, relevant, competent, or material on any issue in the case and serve the purpose solely of inflaming the minds of the jurors and prejudicing them against the accused, then they should not be admitted. However, if photographs are otherwise admissible for a proper purpose, they are not rendered inadmissible merely because they bring vividly to the jurors the details of a gruesome or shocking accident or crime, even though they may tend to arouse the passion or prejudice of the jurors. Generally, also, the fact that a photograph is more effective than an oral description and to the extent calculated to excite passion and prejudice does not render it inadmissible in evidence. That comes from People versus Eddington 387, Mich 551. The photographs at issue in this case clearly show some gruesome aspects of the crime. They are, however, pertinent, relevant, competent, and material in that they directly address elements of the alleged crimes in this case. This is a proper purpose that goes beyond simply inflaming the minds of the jurors. The photographs have significant probative value that bears directly on elements of the alleged crimes. That significant probative value, I don't believe, is outweighed by any danger of unfair prejudice in this case. The court may also exclude evidence where it is cumulative. Photographs 20A, 20B, 2A, and 2B all depict Ms. Warner's body wrapped in the blue tarp. There does not appear to be any additional value or information to be gleaned from a review of all of them, and therefore I would limit the people to one of those 4 photographs, with the other photographs being admissible. I did say earlier that I was holding off on photograph 18, which is the photograph of Ms. Warner's right hand with some jewelry on it. And I was holding off on that, Ms. Wise, because I wasn't certain what the purpose of that photograph was or how it was to be used in evidence in this case.
Your Honor, one of the stories that the defendant told early on was that she's always wearing a bunch of jewelry and this would make her a target. Basically some stranger took her. So that would go to refute that argument, Your Honor.
Okay, Ms. Chardy, is there anything further you want to say on that issue?
So the issue of that would be Mr. Warner was asked repeatedly by law enforcement to try to determine where Ms. Warner was. So what does he think happened to her? What could have happened to her? When listening to the interviews Detective Greca actually came up with ideas that Mr. Warner shut down and said, no, that's not likely. That's not likely. So trying to answer law enforcement questions, and then the fact that she only has 1 ring or 2 rings on her hand when he indicated that she does like jewelry certainly is not relevant in terms of showing the photograph. The other thing is I think all of her children will admit she liked jewelry. And I think the detectives looking at the amount of money she spent at the jewelry store will affirm that. She spent a large amount of money on jewelry, which is fine. She liked jewelry. That's not a reason to admit a photograph of a hand from an autopsy photo with a ring on it.
What I'm going to do is hold off on making a ruling on that and wait to see how the evidence comes in at trial to be able to make a determination on whether or not there's relevance there.
Thank you. May I just confirm, so number 1 is excluded, 18, the court is holding off to determine what the testimony is, and then the government has to pick 1 photograph from 20A, 20B, 2A, and 2B?
That is correct.
Okay, terrific. Thank you.
Terrific.
Okay, and then the last issue was some statements about the purchase and use of a lake home and the admissibility of those statements. Under Emory 8033, which is the then existing mental, emotional, or physical condition exception to the hearsay rule. That rule allows statement of the declarant's then existing mind or emotional, sensory, or physical conditions such as intent, plan, motive, design, mental feeling, pain, or bodily health. In this case, we're talking about statements made in 2018 or 19 about the purchase of a lake home. I think that these statements are remote in time from the alleged crime in April 2021. While they do speak to Ms. Warner's plan to use the lake home as a safe house when the Warners had a fight, this was a plan that she had 2 to 3 years before the alleged crime. Her plans during that time, I don't think have significant relevance to the allegations in this case. Even if there is some relevance, I think that that relevance would be outweighed by the danger of unfair prejudice to the defendant, that the jury may consider it more as character evidence that since he behaved in a way that made her leave the home in 2018 or 2019, that he must have behaved in a similar or violent fashion in 2021. So I would exclude those statements from 2018. And so I think that brings us up to speed with all of the motions that were filed today or were previously pending.
Anything else?
Correct, Your Honor.
That's correct.
When Ms. Charday was asking for clarification, I didn't hear her bring up the other one, so I just wanted to clarify in the photographs that photographs 3 through 15 and photograph 19 are admissible. And I apologize if you said that and I didn't hear you.
So I had 3 through 17 being admissible, 1 of 19, 20A, 20B, 2A, and 2B, and then reserving a decision on 18.
Thank you, Your Honor.
All right, I think we're all set for today. Thank you.
Thank you, Your Honor.
So this case is going to be a fun one. I get all upset when you see attorney-client privilege being trampled on a little bit, and it seems that Michigan here has figured out how to do that by saying, well, you should have known when it said recorded phone call You should have known. I think the burden is on the state, not on the attorney on this one. That's where I stand. We're going to record all the phone calls. No, there are some you're not allowed to record. It's not that we have to do things so that you don't record them. I think the burden should always fall on the state to identify, and as soon as they identify, not proceed with listening to or recording those calls. Yes, there's a process she can follow that will get her phone number when it calls in excluded from the auto record thing. I'm fine with that. And yes, she probably should have found that. But even when the calls were recorded, to have the detective being like, hey, I'm working out this morning. What should I do? Let's listen to some of the jail calls, see what they were talking about, and listen to all the attorney-client things. Like, he's talking to the attorney. Run another mile while I listen to this. That was bad. That was bad. And then for the prosecutor to admit that, she's like, I listened to these, and sure enough, there's a recording on there that says it's recorded. And then she's like, hi, Mr. Warner, it's me. Yeah, prosecutor, why would you ever put yourself in that situation? I think that is an appellate issue or a potential appellate issue, especially when the judge, I think he ruled on this based on an unpublished opinion. This isn't like established case law. It's just some reasoning he tends to agree with. So I guess, starting a murder trial with some big old question marks in the appellate category is an interesting way to go. But that's the way they're doing it in Michigan. That's going to be a fun one to follow, although it also falls and overlaps Corey Richens. So, all right, let me go back to regular size. We have the documents that we were talking about yesterday from the Tyler Robinson case. About 80 pages worth is what it boils down to. And lucky for me, Utah charges for the search, but only charge a set fee for the documents. So I got all 80 pages for just $1. Bing, bing. Always like saving some money there. And yippee. I was just looking at these documents right here. This is, it's actually like 97 pages, I think, is what we're looking at. Where's my mouse? It's right there. This is the motion from Tyler Robinson's attorneys specifically about, let's see, this is the closed session. Commenced, everyone says hello, they're all there. We've got the court, Mr. Nestor, Richard Novak, Stacy Weiser here on behalf of Mr. Robinson. And then you've got the state there as well with Mr. Ballard, Christopher Ballard on behalf of the state, and Jeff Gray, Utah County Attorney, Chad Grunander, David Sturgill, Brian McBride, and Lauren Hunt also representing the state. So a full team on the prosecution side. Then we've got Ben Van Noy from Utah County Attorney's Office, representing Utah County Sheriff's Office. And so everybody's there. Lots of players in this one. And the majority of this, I think they were talking about some security issues. Specifically, they're talking about shackling or unshackling, or not shackling. To shackle or not shackle? That is the question. If Shakespeare was reporting on this. So I'm scrolling through. The first thing they're talking about, they want their client's hands available so he can take notes. This highlighted thing is not working very well during the hearing. He says he's to be able to participate in your own defense, you've got to be able to make some notes, right? And if he's handcuffed the entire time, that's a problem. And that's, we're talking about a hearing. I think during the trial himself, he will be unhandcuffed. He can't appear to be in custody for the jury there. But redacted but open to public scrutiny now. Yes, this is what we're looking at. Thank you, Red, for that. Did I lose my... I did. Go here. Replace pin. And everything's in the wrong place because that last hearing had us in the wrong order. Let's run to A. There we go. All right. I need a mouse. This computer needs a mouse. The worst part is I know I have one. Maybe it's this one. Nope. Okay. We'll figure it out. Chris Wallace Member for 30 months, OG, says, been gone for the holidays, but I'm back in time for my OG status. Thank you very much, Chris. Hope you had a great holiday trip, and welcome back. Some of this is still redacted, very little, but did that go on the screen? Thank you, Chris. Appreciate that. All right, so we've provided him with paper and pen. I can tell the court after spending 2 hours in the room with Mr. Robinson today, I can't imagine any reason why he can't take notes during this hearing. Our client is a great guy. He's a good guy. He wouldn't hurt a flea. So let's unshackle him. There's no reason why that would jeopardize his safety or the safety of anybody else. So to start the hearing, we need at least a minimal level of unshackling. Can we have unshackling level 2, please? He's not able to write and take notes during what we anticipate could be an extended hearing. We'd like him to be able to do so. It's a sealed hearing. The public's not here, so we just can't imagine any specific reason why he can't have one of his hands free for writing. And the state's like, what do you, and the court says, state, what do you think about this? And they say, given the substance of his motion, I would object on the sheriff's behalf. This is the heart of what we're trying to decide. This is a pretrial proceeding, but we would request that be denied, as it should be in all pretrial hearings. Thank you. And all right, is there a way to unshackle one hand for him to be able to write that doesn't comprise the rest or compromise the rest of the bailiff says these are our security procedures. The court says, all right, let's go ahead and proceed with that. Mr. Novak says, thank you, and Your Honor. While we're waiting, I don't care if this is on the record. I have a really bad sore throat, so if I put something in my mouth, it's not gum and it's not candy. Okay, I want the audio from this. But if anybody wants a Ricola, I'm happy to share them. So we get a shout out to Ricola in court, and it's on the record as well, which this is why we read these, and this is funny. Britt Bottom's New Year's resolution, object louder. Object louder. Twubble, member for 19 months, Britt Bottoms and Twubble. Both of you, I know that you are both OGs. Twubble says, so happy that you still put up with me. Of course, of course. All right. They're not done here. I'm happy to share them. Court says, all right. Mr. Novak says, thank you. The court says, depends on the flavor. Mr. Novak says, it's original. Okay, some of them are nasty, says the court. Not a fan. There goes the sponsorship. Court had an opportunity for Ricola sponsorships, and now it's gone. Mr. Novak says, no, I don't like any of that stuff. All right. And before we begin, just want to make sure that we're on the same page on the issues that we're addressing today. Mr. Novak, if you wouldn't mind just touching on the topics that you anticipate presenting, and I want to make sure we're all in sync with what's being presented from both sides. Mr. Novak says, agreed, Your Honor. I appreciate the invitation to sort of do the roadmap. So on Mr. Robinson's behalf, we filed a motion. We filed a motion to permit him to appear in civilian clothing and without restraints in all hearings. That motion is fully briefed, and we understand that's the primary reason why we're here today. Obviously, the court knows that we interpreted part of the state's opposition as a motion to actually limit the types of appearances at which Mr. Robinson would appear in person. The state doesn't want him to be there in person for some of these hearings. And we treated that, even though it wasn't designated as a motion, and we filed an opposition to that. The state has not filed a reply. Shelly Kelly, 17 months. I finally start my new job in January, fully remote, so I can still listen to RA. Happy New Year, all. Shelly Kelly, congratulations on the new job. Hope you love it. Hope they pay you all the money. I hope they pay you all the money. The state, let's see, the state has not filed a reply. I don't know if that's just because of timing or if the state doesn't intend to file a reply. So that may be a question for counsel for the state. But we also filed a motion to strike the state's opposition to our primary motion because we believe it is impermissibly a pleading filed by a non-party. The motion to strike is fully briefed. That means they've written out the document. It doesn't mean it's wearing a pair of underpants. Just for those that were curious, it doesn't mean that it's got its undies on. And in fact, Miss Nestor is going to argue the motion to strike if the court is prepared to hear arguments on that. So I can go a little further down the road of what other issues we think are connected to this case. And also, just so the court knows, counsel for the parties met before the hearing about, I think, one other motion that is partially briefed and some other motions that the parties plan to file in the near future. Fully remote. That's a good job. I'm fully remote. Parties plan to file in the future. What this part right here? some other motions the parties plan to file in the near future. Guess what this is? This may have reference to the media coverage and how some parties want to exclude all the media coverage. Everything, like no cameras in the courtroom style. And we actually wanted to talk to the court about our proposed sort of briefing schedule for that when we might have hearing depending on the court's schedule. So it's not super linear, right? There's a little bit of complexity there. The court says, sure. Novak continues. Do you want me to mention the other slightly related motions now, or do you want to deal with that later? The court says, let's do that so it's all out there and we can see the trajectory of where we're going. Mr. Novak says, okay. So I think the two issues that relate most squarely on our primary motion to appear in civilian clothing and without restraints are, one, a motion that we intend to file on behalf of Mr. Robinson to completely eliminate all video and audio broadcasting or delayed feeds of court proceedings. They shot for the moon. We don't want any video of this trial to be released ever. And we knew this was coming. And I don't think they're going to win this one. I hope they don't win this one. There's so much public interest. You can't say shot. They went for the moon. How about that? But this right here, we intend to file. Read this again. This is defense. Mr. Novak saying, we intend to file on behalf of Mr. Robinson, the defendant, to completely eliminate all video and audio broadcasting or delayed feeds of the court proceeding. And we haven't briefed it. We're not going to argue it today unless the court decides it wants to hear preliminary argument, but the parties have discussed the fact that we're going to bring that motion. And I think that we will bring that motion regardless of the ruling of the court on Monday on the shackling and civilian clothing issue, okay? So that's one. So we don't care if you say, fine, he can be, unshackled, he can be, it's all great. It doesn't matter. We're still going to ask for no cameras. So that's one. The second is this court's sua sponte pretrial and trial publicity order. Sua sponte means the court does it on its own without any prompting from either side. So the judge just issued a pretrial and trial publicity order, which the state has informed us they're going to seek both a modification and a clarification of. And we were also, even though we knew that, we're going to move the court to modify it. The reason we believe that these are all related to each other is because we, meaning Mr. Robinson and his defense team, are very concerned that the nature, content, scope, pervasiveness of the pretrial publicity of the statements that have already been made by law enforcement officers, by lawyers, by the representatives of the state in this case, may have significant impact on the fairness of this trial. This is the ace in the hole. Okay, the fairness of the trial rules supreme above other things like freedom of the press. Okay, that's the danger. So if the openness impacts the fairness of the trial, then the freedom of the press gets restricted in the interest of preserving the fairness. And so modifying the pretrial publicity order, addressing the cameras in the courtroom, and frankly addressing the individual's propriety of shackling in the courtroom all really relate to the fairness of the proceedings. There are two other reasons why shackling, we believe, is the current shackling protocol and practice with respect to Mr. Robinson is unconstitutional. But those don't relate directly to the fairness of the proceedings in the traditional sense. There's another motion, which we've also discussed with counsel for the state, and we're well aware that we're going to do this. They're well aware that we're going to do this. And this is a motion to actually disqualify the Utah County attorneys from representing the state in the prosecution of this case. This is if you could put this motion in a shirt, it would say on the front, "May the bridges I burn light my path." Okay? They are going all out. There's nothing hold my RICO on. Yes. There's nothing that they aren't attacking and going for. They're just, oh man. So they want to disqualify the county attorneys. In this case, they might have a great reason, and so we'll go into that in just a minute. If the Utah County attorneys want to represent the sheriff as an entity for security purposes, that's a different issue. We are focused on whether there is a conflict of interest. That's a key word, conflict of interest. And we are in a sealed hearing, correct, Your Honor? Can we talk privately? The court says yes. Mr. Novak says, okay, so I'm not trying to pre-argue the issue, but the Utah County attorneys have advised us that a family member of one of the attorneys was present at the incident at which Mr. Kirk was shot and killed. And this child, I don't know if they're an adult, but I'm not referring to them as a minor. This child was present, observed it, and was within 85 feet of Mr. Kirk when he was killed and had to flee, that the Utah County Attorney's Office was all advised of this, that law enforcement were actually deployed to the area with her safety and status in mind. Okay, this is, law enforcement were sent there just to protect this child, which is a her. I'm not trying to pre-argue this, Your Honor. I'm not saying anything that we haven't already discussed a couple times with counsel for the state, but we're going to file a motion to disqualify. And all of these motions, we've already talked about getting them all filed before Thanksgiving. That doesn't mean that we want the court. Remember, this was in October that this hearing went down. We just barely got it released the other day. That doesn't mean we want the court or anybody else to work over the holidays, but there's a lot of work there. And so we need, a few weeks to get all that done. This court may have some preferences for how those motions are triaged, if I may, but those are the sorts of circling around today's motion, and I think I should stop talking here. Better words were never spoken. The court says, all right, and to the state, I just want to make sure that, from your perspective, that the same understanding that we're addressing today, I just don't want to go down the path and then one side says, wait a second, I thought we weren't going there. I just want everyone to start with the same starting point. Mr. Ballard from the state says, that's perfect, Your Honor. With respect to what's at issue today, we agree it's the motion to strike the state's response, the joint response of the state and sheriff's office, and also the substantive motion about clothing and restraints. The state did not make an affirmative motion in its response, so that's why the state has not filed a separate reply. So, and I'll explain the latter during my argument, but from the state's perspective, those two motions are fully briefed, ready to go for the court today. So far as the three motions that counsel mentioned, I think that's all the state's understanding as well, that those will be filed. We'll do our best to respond expeditiously. We are very interested in getting the preliminary hearing set in this case as soon as possible. And we anticipate that once we get those motions resolved, or at least argued, then we can move forward with setting a preliminary hearing date. There is two other motions that I think the court should be aware of that are docketed. There is a defendant's motion to preserve evidence. That's docket number 75. The court entered a premature order on that motion. That's docket number 107. And the state has filed a motion to set aside that premature order. That's docket number 116. And defendant's response to that motion is due in early November. And then from our perspective, the defendant needs to file a reply in support of the motion to preserve the evidence. Mr. Novak says, this is back to Tyler Robinson's attorney, we may be able to meet and confer on preservation of evidence and eliminate adversarial litigation about it. Because I just think that we may be able to do that. We'll try to do that. It's really a question of what evidence needs to be preserved and what advance notice needs to be given to us before biological evidence can be used, even if it might disappear. And so we're going to try to at least try to meet and confer about that. We may have different definitions of materiality, but we'll do what we can to eliminate these things that maybe we can agree upon and not burden the court with another set of briefings. Okay, so there are some materials, case material, evidence that when processed is used up. Say like it may be a limited marking of DNA, a limited amount of DNA, and you can run the test once and then it's gone. Okay, and they need to agree on if there's a certain piece of clothing that we have to run this test on and it destroys the clothing to complete the test, are we okay with that? And they say we can probably work that out together. The court says, all right, I appreciate that. Anything else, Mr. Ballard? Mr. Ballard says, no, Your Honor, thank you. The court says, so the one concern that I have is, and I appreciate counsel laying this out, is the issue of the media and photographs and video, because this is very ripe. We have a hearing on the 30th, so I'm just trying to get an idea of where. It concerns me that the judge has the concern about the media. That's not a good sign. Let's see. we have a hearing on the 30th, so I'm just trying to get an idea of how much time do we need, because at this court's it's intertwined. And so I'm looking at what decisions to make, which is an important consideration because it touches upon the issues that we'll be talking about today. And so where are the parties at with that, understanding that we have a hearing on the 30th? Now, specifically about media, Mr. Novak says, I think we're at, after speaking before we came into the courthouse, is we're not especially since we're here today, we're not sure we actually need a hearing on the 30th. The court says, okay. Novak continues, we've discussed that with Mr. Robinson. He understands the consequences of further delays so that we can raise these issues and litigate these. I don't want to speak for the state, but I think our idea is, given that we need, like I said, before Thanksgiving to file the motions we're talking about, maybe the court wants to suggest a hearing date in early January. We will get all the briefing done in time for that, or whether the court is ready to do that after the holidays. And we don't need the status conference. The court set the status conference before any motions were filed. So it makes sense that it's on calendar, but now we're here today. We just don't think that there's a need for a hearing. We certainly can't file, brief, and represent that it's submitted to your honor before the 30th on any of those. Court says, okay. Mr. Novak says, so if the court's comfortable with vacating the hearing on the 30th or postponing it, or however the court wants to fashion its scheduling, that's fine with us. We don't need to be here next week unless the court wants to hear further argument on something that we don't cover today. Court says, all right. And to the state, Mr. Ballard says, and your honor, the state agrees with that approach. We don't think we need, given everything that we've been able to do today and will be able to do today, we don't think we'll need the hearing on the 30th. Court says, all right, well, we can address that at the end of today's hearing. All right, well, it looks like we'll be addressing the motion to strike and the dress and restraints issue today. So with that, let's go ahead and move forward. Mr. Novak turns it over to Ms. Nestor, who is going to be able to handle the motion to strike. And I'm going to sit down. Thank you. Mr. Novak sits down. Ms. Nestor stands up and says, good afternoon, Your Honor. Kathy Nestor on behalf of Mr. Robinson. May it please the court and counsel. Your Honor, the motion to strike, obviously, it's more of a procedural complaint that we have than the substance that Mr. Novak is going to cover with you about shackling. But we had some concerns in the manner in which the state replied. And I do think there's a little bit of confusion. I think they're trying to strike the state's reply to a motion they filed. I do think there's a little bit of confusion. I think we were all really trying really hard, admirably, to get to court quickly on this issue because we all recognized this matter needed to be resolved before any additional hearings were held. And we're very grateful to the court for what you've done to get us here quickly. And all the orders you issued trying to accomplish that. We appreciate that very much. And we know that's what's happening. I do think there's a little bit of confusion. The first order that came out by the court, it came out on the October 13th. And in that order, in our motion, we made very clear, and Mr. Novak will get into all the details here, so I don't want to steal his thunder, but we welcomed the participation of the sheriff in this process. We recognize that the sheriff would have important information that the court would need to take into consideration in making findings on our motion, our anti-shackling motion, if I just call it that. So we invited that. We expected that. We asked that the court consider whatever documents the sheriff needed to participate with, that they would be looked on as an ex parte basis. We certainly recognize that it might not be judicious for us to see the inner workings of all of the jail. We frankly don't want to know any of that. So we had already laid the groundwork in our motion for this information to come from the sheriff. We welcomed it, we wanted it, and we think it's appropriate. We were a little bit surprised when we get the response in that it appeared to us, it's apparent on its face, that the sheriff is entertaining an appearance of us as a party with this pleading, that they're actually, though through Mr. Vanoy, are lodging objections to our motion as a party would. That would just instantly raise concerns with us. First of all, because we're looking at a very long case, this case is probably going to last a long time, hopefully. And we're very concerned about right from the get-go, precedent being set where the sheriff can enter an appearance in our case, lodge objections to our motions, and appear through counsel to be heard, that we certainly were not inviting that in our motion that we filed. We felt strongly compelled to shut that down quickly and permanently. So this is strange. Basically, the defense says, hey, Judge, we'd ask that our client be able to dress in street clothes and not be shackled for the hearings and trial. And the sheriff shows up with a lawyer and says, we're filing a response to this motion. Normally, the sheriff would be represented by the bailiffs in the court, and they'd work through the captain, and the judge would make a ruling in association with that court counsel. It's sort of strange for the sheriff to be involved so closely. Red Pen says fast forward. Fast forward. We're scrolling for dark stuff. By dark, I mean black. Sharpie stuff. All right. We've got some more shackling in the courtroom. When Mr. Robinson was first arrested, let me see who's talking here. I think this is Novak, because he's been talking for a long time. Okay. When Mr. Robinson was first arrested, blank, and I think it's interesting that the Sheriff's Department hasn't provided the court with any information as to why that is, that he has convinced the Sheriff's Department that that's not necessary. Okay, they're talking about medical records. Okay, so we appreciate that the Sheriff's Department is concerned with the safety of the court and all the participants. We were here a few weeks ago, and it was clear the Sheriff's Department took the first appearance of counsel very seriously, and we appreciate that. Something. That's not Mr. Robinson. So we don't think the intense public interest was maybe drawing in unstable fringe people from the left and the right and the center and other places is imputed to Mr. Robinson. The question is, can the court trust Mr. Robinson to sit the way he has been doing for the last hour and respect the decorum and dignity of the courtroom, just like the court would expect him to? We think the answer is obviously yes. So the sheriff clearly has some concerns about outside security issues that may choose to interject themselves or become involved in the court proceedings, either through protest or through action. Let's see. Let's continue to go down here and see what else they redacted from us. And while we understand that there's a lot of what I call noise, there's noise on the outside. Okay, blank. Maybe not. I saw one person with the camera in the lobby today. I don't know. We also got here at 2:00, so maybe there was more, or maybe nobody was interested because it was going to be a sealed hearing. But none of that affects Mr. Robinson's right to be free from shackling in the courtroom absent this individualized showing. If we need to have evidentiary hearing about an individualized showing, we can do that. I've already hinted to the court that the sheriff has information, and I don't think it's duplicitous or secretive. I just think that we're saying the court needs to make an individualized determination. The sheriff has information that the court may or may not want to review, but it's their burden of proof, and we're not waiving Mr. Robinson's right to protect the confidentiality of his information. We're not trying to run away from it, but we're not trying to lodge it as an exhibit that needs to be shown to the people, to the state, because it's their burden to make that individualized showing of risk. So long as this court permits cameras, whether it's video or still cameras, to broadcast either live or with delay proceedings in this courtroom, we also believe that Mr. Robinson should be dressed roughly like everybody else because the entire world has already seen him, because the Sheriff's Department released a booking photo, and because there were cameras in the first remote appearance in this case, has already seen him in jail jumpsuit with a vest on. Redacted. But if he's going to be in the courtroom, and we're going to have a secure courtroom, and it's going to be broadcast to the world, he should not be depicted as a jail inmate. He should be depicted as a citizen of the United States with a presumption of innocence. And that is why we believe he should be able to appear in street clothes that are consistent with the court standards for what kinds of clothing individuals can wear. If he shouldn't have shoelaces, we can get him shoes without laces. If he shouldn't wear a tie and it's cold, we'll get him a sweater. Unless we're going to shut down all the video and all the photography of what goes on in this courtroom, he shouldn't be wearing jail stripes. So what part of it maybe is wrapped up in another motion that we're going to bring to the court? As we said before, we do believe that in the absence of the individualized showing, the shackling should end right now. I don't think there's anything more I want to say unless my colleagues tell me I missed something, and they're shaking their heads in the negative. So with that, I'll sit down and see if there's any reply when that's done. Thank you, Your Honor. And Mr. Novak sits down. The state says there are two issues. First, when is he actually required to be here? And when he is here, what security measures are necessary because he's here? I think protect the defendant's presumption of innocence would be to keep him away from the case. He has a right to be involved. Whether the defendant's presence is necessary, I think the court can resolve many of those concerns by holding non-critical hearings, either virtually or hybrid, with the defendant appearing from the jail. So the state doesn't want him in civilian clothes. They just don't want him to be there at all. Okay, let's see if we can get to the more juicy stuff. Still talking about restraints. Okay. Still talking about the clothing. Let's see. This is a funny one. The idea that because Mr. Robinson may be changed clothes before or after the charged shooting has nothing to do with Mr. Robinson sitting here in a sweater and blue jeans, or whatever the sheriff and Mr. Robinson's counsel agree is appropriate clothing, could somehow turn into Superman, by spinning around in a circle. It's just not going to happen. I have no problem with it, but there have been something. So I think Your Honor is saying, why does he need to be in prison garb when we have all the security in the courtroom, generally speaking? So I think he's going to be in civilian clothing. I think we're going to get cameras as well. That's my take. Further redactions, more about civilian clothing. More about the restraints. Let's continue down. Court is so exciting. Love this stuff. I think we're done. And that's the end. What's the bottom? Judge says everyone behaved themselves today. That was good. You all get a gold star. Have a good weekend. The court's in recess. And then we've got the signature of the recorder. And I love that they do this. Not all courts do this, but the transcript, because this is a transcript, it has the table of contents on the back, so you can search for the presence of every word and when it occurred, all the way through the end. Noteworthy reporting LLC. I made that happen. All right, so not the smoking guns or spicy hot. The index is amazing. The index, yes. Table of contents is at the front. Index is at the back. I'm sorry, red pen. My English teacher would be disappointed in me. So the issue may be a self-risk to the clothes if he's allowed to wear. Shoelaces, neckties are not allowed, so that is extra. Right. That's pretty standard in a lot of cases. You don't get shoelaces. You don't get belts. Unless the belt is applied by the sheriff and it has a shock thing and a device involved. All right, where do we go from here? Let's do a quick check around the interwebs to see what is happening in the world of true crime. And wow, somebody's busy. This Judge Simpson.
I left the store with the items on me. And didn't pay for it.
I heard none of that. What did you do that makes you think that you're guilty of this offense?
Because I walked out the store with the items.
All right. So you went into the store, you picked up some items, tried to walk out of the store without paying for them?
Yes, sir.
All right. And you didn't have anybody's permission to do that, did you?
No, sir.
The store was open to the public at the time?
Yes, sir.
And are we doing this on value? And was the value in excess of $200? Of course it was. It's Lululemon.
No.
But go ahead. Was it in excess of $200?
No, sir.
Sorry. Yes. All right. Ma'am, if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules,
apparently Lululemon is expensive.
The court would no longer be bound by any sentence evaluation, and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Counsel, have I complied? Well, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
People are not. Defense is not, Your Honor.
And have I complied with the court rule?
People are satisfied. Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
at 9 a.m. before Judge Valvo.
January 20th, 2026, 9 a.m. before Judge Valvo or her successor. Bond will continue.
I think that's how they started out, but they've branched out. In addition to buying Miss Me jeans at thrift shops, I'd also buy Lululemon. Even used, they have a really high resale value.
Stephanie Cannon on behalf of Mr. Lyle. Mr. Lyle, you're at the lectern. Please state your name for the record.
This guy's tall.
James Lyle.
Thank you, sir.
He came out of jail with
Your Honor,
sunglasses on?
we are going to request an adjournment of this matter. I do have a green sheet.
Is this the only thing holding him, or?
Your Honor, I do believe this is the only piece of parole. He has a parole hold, Your Honor. However,
He has a parole. Okay.
yes.
Of my appeal, I already said this situation is taken care of.
He's spoken with his parole agent, Your Honor, and it's his belief that if he is able to get a PR bond in this matter, they are going to be able to.
When I was arraigned, the judge and the lawyer said that they put it at $100 bond for now, so I can get time credited, but I can get the PR bond if need be. Just revert back to them and they'll switch it to the PR bond. So I'm good with the PR bond. If I'm still going to sit.
I don't have that, but I don't know what they're going to do if they release you, because parole is going to take you. So I'm not going to do that.
No, I don't want the PR bond.
Then he is asking that we set it for a preliminary exam, Your Honor.
You don't want the adjournment.
No, Your Honor, he's asking for a preliminary exam.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 13th.
We'll try for that day. Thank you, Your Honor.
Preliminary examination in person, January 13th, 2026, 9 a.m. before Judge, 15th District Court Judge. Bond will continue. Does call the case People versus Amber Corpus. Yes.
Morning, Your Honor. Jay Grant Miller, P58658 on behalf of Ms. Cormos. She is still en route from Jackson. She was having some difficulty getting here this morning.
I'm sorry, right? I missed it.
She is still en route from Jackson. She was having some difficulty getting here, some car troubles. She has been texting me.
What?
Chauffeur.
You have her in Zoom?
Yeah, we're fine.
But she doesn't have permission to appear busy.
Uh-oh.
That is my understanding as well, Your Honor.
I don't know why she's on Zoom. Well, when it passes it, somebody better tell her how to get here, or we'll come get her.
Yes, Your Honor. Thank you, Your Honor.
Court calls the case People versus Devon Reed.
Ashley Phelps for the people.
Your Honor. Brian Bowling on behalf of Mr. Reed.
Good morning. Your name, sir?
Reed.
Thank you.
Judge, I'm just asking for an adjournment to obtain some video in this matter. I speak to the prosecutor.
That's correct. We talked yesterday.
Is he held on anything else?
Yes, he is.
He is.
Yeah, multiple matters.
Multiple matters? All right, then. Any objection to going to the 29th then with him, or is that too far for?
I guess I'd prefer a sooner date if the court would be willing.
Okay, I can give you a sooner date. No one here we call January 8th.
Thanks, Judge.
We'll just squeeze him in. 9 a.m. bond continue.
He appreciates that, Judge. Thank you.
Well, he won't that day, but that's okay.
I didn't catch your name, but somebody on Zoom is
The court does call the case
picked up.
People versus Tabitha O'Carroll.
Assistant Prosecuting Attorney People. Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Miss O'Carroll. Sorry, she was waiting outside due to the crowding. Please state your name.
Tabitha O'Carroll.
Your Honor, I've spoken with the prosecution and I just need to submit some paperwork for a no contest plea due to a memory issue for my client.
January 29th, 2025, 26, 9 a.m. bond continued.
I forgot I committed a crime. Memory issue.
Court calls case People versus Kevin Smith.
People.
How many more in custody do I have?
Assistant Public Defender Davey Lipa from Mr. Smith, who stands to my right. Mr. Smith, can you tell the court your name, sir?
Kevin LaVarn Smith. Thank you. What are we doing?
Your Honor, I believe the court should have a plea form.
Plea form in front of me that indicates the defendant is going to be pleading guilty to an added count two of larceny, 200 to 1,000 to 1 year offense. Upon his successful plea to that charge, count one would be dismissed. The defendant agrees to undergo a mental health assessment, comply with all mental health treatment as ordered by probation. That's the court's full understanding of the agreement. May I have him sworn?
Raise your right hand. You solemnly swear in front of the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Yeah. State your name, please. Kevin Smith.
Sir, it is his court's understanding you're going to be pleading guilty to the charge of larceny, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
When will that be?
Well, I haven't given you the date yet. I'm just apprising you that you would be sentenced before a different judge than me.
All right.
You understand that?
Yeah.
Okay, you okay with that?
I ain't got a choice.
Well, yes, you do. You absolutely have a choice. Because if I'm taking your plea, you have a right to be sentenced before the judge that's taking your plea.
Right.
All right. What I'm apprising you of, and the box is checked about the sentence judge waiver, is that you would be sentenced before Judge Perry instead of me.
I'm fine with that.
Pardon?
I'm fine with that.
You're okay with it?
Yeah.
Okay. So, understanding all of that, do you still wish to plead guilty to this charge?
Yeah.
Okay, to the charge larceny, 200 to 1,000. How do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind?
No.
Okay. You understand that you will not have a trial?
Yes.
Okay. All right. And a advice of rights form was signed with your permission. Is that correct?
Yes. But I also got to say that even though I'm from a different county.
You're from a different county?
Yeah, I'm from Jackson County.
You question jurisdiction.
So probation, I don't know how it works.
Well, I would let that court, 15th District Court in Ann Arbor, figure that out.
All right.
All right. They might keep you and you still would be from Jackson County, but okay.
All right.
Okay. So you signed that advice of rights form. Do you have any question, or had it signed on your behalf? Do you have any question regarding any of those rights?
No.
All right. If you look down on the podium, there's a copy of one. You understand that you're waiving the rights under paragraph 5, as well as all the rights that are on that form.
Yeah.
Yes?
Yes.
Okay. You understand you're giving up your right to appeal of right?
Yes.
All right. Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been said here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
All right. On the date of May 14, 2025, at the location of 343 South 5th Street, City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do at the public library that makes you think that you're guilty of this offense?
At the library?
Steal books. You stole books?
Yeah.
Okay, so you went into the library and you didn't check them out. You just tried to walk out without doing anything? All right.
I need to know
and
why. Generally, you
didn't have
don't steal
anybody's
books to
permission
resell
to
them.
take those books, did you? All right. And these books that you took, these books belong to the public library?
Yes.
All right.
Somebody get him some books. What is he looking for? Mr. Robin Finney.
You don't know what the value of the books you took were, do you?
No.
All right. So, counsel, I would accept a higher plea to this charge unless you have information regarding the value.
No, Your Honor. I would also note there was a die cutter that was recovered from that was also library property. So I think the higher charge would be fine for the people.
I agree.
Okay.
Okay. So he was just taking
All right. Sir, I do have to advise you that if between the time I accept your plea and the time the judge sentences you, that you commit any type of misconduct that, as defined by the Michigan court rules, that you would not be entitled to any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
Not known to defense, Your Honor.
All right. And have I complied with the court rule?
You have, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2 under the theory of the higher charge. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
30th at 8:30.
January 30th, 2026, 8:30 before Judge Perry.
Thank you, Your Honor. And may I address bond?
You may.
Thank you, Your Honor. Mr. Smith does have significant mental health issues. He's now taking medications for these. He will continue to do so if he's released. He can stay with his mother if released, and his mother has indicated to me that if he does stay with her, she would intend to keep a very close eye on him.
All right. At this point, I'm going to deny the request. I'm going to let probation at 15th see him. I'm not going to have a problem if they wish to release him.
Thank you, Your Honor.
I'm going to deny bond at this time. So bond will continue. Thank you.
Yes, most probation recommends being released early.
All right. Thank you, sir. This one. Court recalls case, People versus Timothy Palmer.
Water Assistant Prosecuting Attorney to the people.
Good morning, Mayor. Please, this honorable court. Kareem Johnson, appealing on behalf of Mr. Palmer.
That's me.
All right.
Kareem
Your
Johnson.
name, sir?
Timothy Palmer.
All right. All right. What are we doing on this case?
Somewhere else. Let's run over here.
Your Honor, there is a video of the incident that is missing. We're asking the court for a second PCC date so we can try and get that video from law enforcement.
All right.
It's
not There's a ring camera video. I have emailed the OIC requesting that.
All right. He's out. So what I'm going to do is probable cause, I'll adjourn to January 29, 2026, 9 a.m. Bond will continue.
Thank you very much, Your Honor.
All right. Thank you, sir. Court calls case, People versus Adam Adkins.
Paige and Adam.
Assistant Prosecuting Attorney to the people.
Assistant Public Defender Davy Lebo, on behalf of Mr. Adkins, who stands to my right. Mr. Adkins, could you tell the court your name, sir?
Adam Atkins.
All right.
Thank you, Your Honor. I'd be requesting adjournment. I have not been able to reach Mr. Adkins.
January 29th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Case, People versus Mershond Smith.
Water Assistant Prosecuting Attorney for the people.
Steven.
Brian
Sorry,
Boyd,
bouncing
on
around the
behalf of
screen
Mr.
like a
Smith, Your
DVD
Honor.
player screensaver, corner to corner, but never hits the perfect corner.
State your name for the record, please.
Marcian Smith.
Thank you.
Judge, we're asking this matter be set for a preliminary examination.
Discovery is complete.
I believe it is, yes.
People, other witnesses available the 13th?
Yes, Your Honor.
Preliminary examination in person, January 13th, 2026, 9 a.m. before me. Bond will continue.
Your Honor, may I address bond?
You may.
Your Honor, this is the only matter holding Mr. Smith to my knowledge. There's a $25,000 bond. He indicates to me that he is employed at Toyota in Saline, which is a very good job. He believes he will lose that job if he remains in custody any longer. Further, it's come to his knowledge that the apartment that his fiance and daughter live in Ypsilanti, that they are going to be evicted from that residence if he's not able to be the financial support for those individuals, which ultimately ties to my early argument regarding his job. He indicates to me
the
that
apartment in his name.
It is.
Yes.
Your
Who's the landlord?
Honor. We just moved there. We moved out of Arbor One into this apartment.
What's the name of the apartment complex?
I can't remember.
You just moved out of Arbor One. How long ago?
Like 60 days. We moved out of Arbor One into this apartment. We've been trying
because you were trying.
Because it was
a mess
condemned
over there.
Yeah, it was condemned. And we just got this apartment, Your Honor. I don't want to lose it.
Your Honor, just
okay. Have they started? It's in your name.
The apartment is in her name. Yes.
We don't have anything in his name.
I could try to come up with the lease or something, but if my name is on the lease with her.
You know, when you're winning, you should stop talking.
Good advice here.
See,
Motorola
the
has
way
lit
he
up.
reacted. Thank you, sir. If attorneys would react that way, my day would be so much easier. Anything from the people?
Yes, Your Honor. Your Honor, the facts of this case, Mr. Smith was released on a DV case. It's a city prosecution out of Ypsilanti. Several hours thereafter, the police were called because he had contacted the victim's grandmother. The victim's grandmother called the police, indicated that he had told her that he was on his way over and did not care what happened. There was a no contact and a stay away order in place on the domestic violence bond. When he arrived, police had already gotten there. He was observed by the arresting officer standing outside the door. The officer asked him to stop and come and speak to him. He immediately ran. The officer had to chase him out of the building, down the street, through the snow, until eventually he fell down. The officer tased him. He did not stop. Eventually, he was able to take him into custody. The people are very concerned about his refusal to follow the court's orders regarding bond, as well as his refusal to follow the orders of law enforcement.
May I respond to that? Your Honor, it's my understanding that Mr. Smith, regardless of any other calls that may have been made, was he reached out to the Ypsilanti Police Department for a civil standby or civil assist visit at that residence to obtain some items. It's my understanding he was in communication with the Ypsilanti Police Department, actually received a return call from them, telling him to go to that location. I mean, ultimately, we're here for the allegations that Mr. Overwater just stated happened once he came in contact with the police at that location. But
what happened to the underlying DV?
It's still pending. There is a personal bond on that case. I believe it was scheduled for a hearing yesterday, and nothing was changed.
So that's what I'm trying to figure out. So if the violation is for the underlying DV, he goes there, which would be a violation on that case, and where you would suspect that his bond would be denied.
Fair enough, but
his bond is not denied. He has a PR on that case, and because, all right.
And I mean, I'm not sure exactly what happened with respect to the
call. What did I tell your client?
Fair enough.
Okay.
When you're winning, shut up.
I understand the circumstances, but if there's really a safety issue with this, individual and not being able to follow the orders, that needs to be taken care of in that other case. I don't, as I'm looking at this case, I think his bond is inappropriately set. I'm also, because of his Arbor One situation, I'm a little bit worried if he loses that apartment. He's probably sat in a condemned unit for a number of months, just trying to find a way out. So what I will do is I'm going to grant the motion for bond reduction. His bond in this case will be reduced $25,000 personal recognizance bond.
Thank you.
Oh man.
Thank you, Honor.
And thank you.
He gets a PR.
You're welcome, sir.
Thanks, Joe.
All right. Don't make me regret it. Do the right thing. You hear me?
You won't, Your Honor.
All right. Take care of yourself.
Don't make me regret it, says the judge.
Court calls the case People versus Jamie Bailey.
And Assistant Public Defender Nicholas Buckovich on behalf, but not with
Kimberly's
Mr. Bailey.
crying.
Wait, why are you shaking your head? Wait, no, wait, hold on. Hold on a minute. What? You don't want to talk to him? You don't? I'm not talking to him. I'm going to talk to you. What do you? Go ahead, Mr.
Your Honor, I cannot explain my client's back for appearance here today. I did call the number we had on file, but it was for someone else who told me they were not Mr. Jamie Bailey. So I'll be asking for an adjournment at this time to allow me to get time to get in contact with my client.
Bench warrant will issue. Bond 10,000. Cash surety.
And Your Honor, just for the record, it looks like this person previously failed to appear in September. And then they got arraigned by the magistrate on December 22nd and got a PR. So I'm going to request.
Well, we'll do the 10,000.
Yeah.
And I dare Odie to do it again. All right. This warrant will issue immediately.
Understood, Your Honor.
Court calls the case People versus Mikkel. Is it Urquiza?
I believe it is Urquiza, Your Honor.
And then on behalf of people.
Assistant Public Defender Davia Leba on behalf of Mr. Urquiza. And Your Honor, Mr. Urquiza would like to waive his preliminary examination. And if you'd like
Your name, sir?
Miguel Urquiza. And Your Honor would like to address bond as well.
Of course you would. Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yeah.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Can you give me a second? Yes. Oh.
Oh. How many more of those?
I think it's a good decision, but it has to be. Be desperate. Yeah. Yes, understand.
All right. You understand you will not have that hearing, you'll proceed to circuit court for further resolution?
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 following.
Thank you, and we acknowledge receipt of the information, waive formal reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all charges. Pretrial will be set for January 13th, 2026, 1:30 before Judge Conkey. As to bond.
And with regard to bond, I think the past couple weeks in jail have taught Mr. Urquiza a very significant lesson, both about the seriousness of this case and about the importance of following this court's orders regarding bond. He is 20 years old. He is a college student, University of Michigan. He has a supportive family. I believe both his parents are present in the courtroom today. He's told me he is actually doing very well in school. It's a 3.5 GPA, and he's currently scheduled to go back to school on the 7th. He's also told me that he was accepted recently to him.
Why did he lie to me when he came before me?
Mr. Keith, would you perhaps like to address the court on that?
Regarding to the Adderall?
Yeah.
Well, yeah, I did. Well, a family member did take it, and I made the, a careless decision of taking it. I knew it was going to bring me consequences. I didn't think about the consequences before doing it, and which now, I know.
Once you got caught, so I guess what I don't get is, once you got caught, why'd you lie to me? I mean, I look stupid, but I'm really not.
No, I'm not trying to say that, Judge, but after just.
Okay, why'd you lie? Oh, that's a hard question.
Just say what?
Just say
that. The reason why I lied was I was scared. I just didn't know, the consequences that would be following it.
Really?
And that was.
So how'd that work out?
It didn't work out really good.
It
was
really didn't.
My fault. So, but after spending, almost 2 weeks, in jail, I learned that freedom is like a privilege that many others take for granted. And, after learning that, if given, a chance, I won't take that for granted.
You came up here. It's really funny because you came up here really smug and everything, just doing what you were doing. And I asked you a simple question. You just lied to me, tried to smile at me like whatever it was. And you didn't seem to get it. I don't play that.
I understand.
No, I don't know if you do.
Nope.
Miss Linda?
Your Honor, at this
Lorby,
point, I would
thank
object. I think maybe a release to inpatient might be appropriate at some point, based on the mistest, the THC, the Adderall, and then if it was intoxicated as a part of the underlying charges. So I think there are some issues that need to be figured out before it's just released back in the community.
Your Honor, I have no objection to him being released basically on home confinement with an instruction to immediately get a substance use assessment. But as of now, I don't think there's any reason to believe that he's in need of inpatient treatment.
Okay, let's look at this. How am I going to keep him away from the drugs?
Your Honor, I think the past 2 weeks have taught him that he cannot even think about touching substances.
2 weeks?
I think that's very clear to him now.
So he should have learned a number of lessons.
Don't lie to the
Don't
judge.
touch that. Don't lie to me.
I think this is probably the biggest learning experience of Mr. Keith's life, Your Honor.
Really?
He's got a 4.0 in courtroom.
Would you agree with that,
That's a
Mr.
lot
Keith?
of money to
Yes.
pay for the U of M. This becomes your biggest learning experience.
Your learning experience is about to get bigger, sir.
Where are you from?
I'm from Chicago, Judge.
Oh, he's trying to roll some Chicago stuff on me. That didn't work, did it?
I'm sorry?
That didn't work, what you were trying to do. Why didn't you just come in and tell the truth?
Well, I was scared. Well, I've never been in this type of situation before in my life. I've never been in trouble. I've never been in this state.
Why didn't you just tell me the truth? Did you think lying was going to get you anywhere?
No.
I mean, that's the other part. Did you think it was really going to get you anywhere?
Warby, I get my first next year. I'm so excited.
Why did I have all these missed tests? Because that's the other thing.
Your Honor,
Remember this one test, but it's positive THC.
Right.
Smoking weed.
I'm sorry. I meant to phrase it differently. You don't have a medical marijuana card.
I don't. But after my release, I don't know why I showed up positive and negative.
You don't know why?
No, I didn't. After my release from Washington, I didn't take any edibles or I didn't consume any THC. I obviously knew and learned not to.
Yeah, in those 2 weeks, I learned all my lessons, but I still tested
So
positive and I
how did
missed
it
my
get
drug
into your
test.
system? You're an amoeba.
It's a mystery, Judge. It's a Christmas
It just
miracle.
absorbed into your system? Why do I get the feeling you're not telling me the truth?
Your Honor, Mr. Kiza has indicated to me the whole, pretty much since this violation of THC came to light, that he does not believe he's used THC since.
So this THC, how did it get into his system?
That I don't know, Your Honor, but I.
Really? You don't know? You weren't there with him?
I was not, Your Honor.
Okay, so he knows.
You didn't smoke a doobie with your lawyer?
I don't know. No, you know what, young man? Here's what we're going to do.
I'm sorry.
And I hate holding everybody up, particularly the jail. They've been great today getting these people out. I've got some others that are in custody that have to come out. I'm going to send you back. I'm going to do you the favor of recalling your case at some point when you have a chance to speak with your attorney and decide you're going to tell me the truth. I'm not stupid. Don't say anything, because otherwise my decision is going to be you're going to sit. Take him back.
Didn't have any gummies, didn't smoke anything. 0 dabs.
Court does call the case of the people versus SAR.
Yes, Your Honor, ready.
People.
Morning, Honor. Tyler Velo, P number 75702 on behalf of Penda Star, who is walking up to the podium and will be standing to my right momentarily. And Ms. Sar, when you get to the microphone, can you state your name for the record?
Yes, Penda Star.
Yes, today is the date and time, Your Honor, for a probable cause conference. My office reached out to the prosecutor as late as yesterday regarding discovery, and they didn't have it, but this morning they did, and they told me that they sent it to me, so to my office. So we have that now, but we are asking for a short adjournment here so that we can review that discovery and decide on the preliminary examination.
Cause conference, January 15th, 2026, 9 a.m.
Thank you, Your Honor. Have a great day.
Bond will continue. You need to fill out a green sheet, counsel.
Thank you, Your Honor.
All right. Thank you.
Robin Finney can go now.
Court does call the case, people versus Emily Bates.
I'm the Water Assistant Prosecuting Attorney for the People.
Brian Bowling on behalf of the state. We should be on Zoom, hopefully.
Hello, Your Honor. Happy New Year. Happy holidays.
And to you, Miss Bates. Thank you.
Thank you.
Judge, at this time, I believe the people are going to move to dismiss this matter.
That is correct, Your Honor.
Dismissed.
Defense has provided me with various documents verifying treatment that Ms. Bates is doing here. She's well engaged in mental health treatment where she's currently living. And so in the interest of justice, the people will be submitting a motion to not withdraw, and with the hope that she continues to do it.
No pros.
Any objection?
No objection, Judge.
Ms. Bates, this case is dismissed.
Thank you, Your Honor. It was a pleasure to meet your company. I wish you the best
Okay,
of luck in
and
the
you.
new year. Thank you. God bless.
I was actually going to say that you were, every time you appeared, you were always very pleasant and very nice. And I appreciate that. It doesn't go unnoticed.
Likewise, Your Honor. Thank you so much.
All right.
It
You
was-
take
it was
care of
nice-
yourself.
It was nice to meet
Have a
you
good-
as well.
Have a good New Year.
Thanks, Judge. Thanks, Mr.
Thank you.
Court calls the case, people versus Jade Wimberly.
Assistant Prosecutor, on behalf of the people. Brian Bowling on behalf of Ms. Wimberly, who's approaching.
Trying to remember what Emily
State
Bates
your name
did.
for the record. Your Honor, we're asking for an adjournment to attempt to get some video from the officers related to this incident. So I just asked for an adjournment.
Is this a juvenile?
Do the people have it, or
Defendant is
what?
tiny.
Just got an email from the Hawaii Seed. It was a body cam case from 2018, I believe. So unfortunately, they did not retain that body cam.
Okay. Well, I guess based on that, Judge, we would ask that this matter be set for a preliminary examination.
All right. Discovery would be complete, and would the people have their witnesses available the 13th?
Yes, sir.
Preliminary examination in this matter, January 13th, 2026, 9 a.m. before a 15th District Court judge.
Address bond.
Right.
Judge, Ms. Wimberly being held on a $10,000 bond. She does also have a bond out of the 14A2 District Court, which is a $1,000 10% bond, which she indicates to me that if this court were to grant her a personal bond, she would be able to post that bond. There's nothing else holding her in custody, to my knowledge.
Can't hold her with
as the
handcuffs.
people indicated,
She's
this
too
is an
small.
older case. It involves an allegation of abuse with her young son, who is now significantly older.
Why didn't she show up?
In the most recent hearing in December, Your Honor, she was at a facility called Stonecrest in the city of Detroit. My office was working with Ms. Wimberly's sister, as well as that facility, to try to get documentation for the court, but we weren't able to do that. I believe if she's able to get out, she can present that to the court when she returns.
How long was she in that?
I was in there from January, the second last week of January, all the way to February, past February 14th.
That was the first one back in January, Judge. And then recently, when were you there in December, early December?
December.
Yeah.
I wasn't there in December.
The Stonecrest was in January.
But I guess what I'm saying is,
That's my
we
understanding.
didn't hear from her. She didn't appear before me in January of 2025.
Yes, and that was due to the Stonecrest issue. I had some
Okay.
misunderstanding with respect to
After
December.
that, we don't hear from her until December, and there's nothing. And then the question becomes, how'd you come into custody?
My mother called the police. I didn't even know I had a warrant.
She was arrested on the matter pending at the 14A2 District Court with that bond that I addressed earlier.
Got it. Well, I'm going to leave it in place at this time. I'm going to deny the request for bond reduction bond.
Thanks, Judge. Thank you.
Court does call the case of the people versus Bridget Beck.
Ashley Feltus for the people.
Stephanie Cannon on behalf of Ms. Beck, who should be appearing by Zoom.
Should be. Where are you at?
Bridget Beck.
Bottom center. Asleep. She's asleep. I think she's leaned forward and is.
What? I don't.
She's not your second screen at all. I mean, I see your name.
She's no, she's there.
Oh, okay.
Hello.
Ms. Beck,
Ms. Beck, you need to mute yourself.
you need to unmute.
Oh, can you hear me now?
You can hear you now.
Now we can hear you. State your name.
Bridget Beck.
Your Honor, I do have a green sheet for Ms. Beck. Your Honor, this case is kind of old, but I don't
Kinda
have.
old.
Yeah, I don't have any discovery yet. I'm not sure whose case is. Sorry.
It's old.
So I'm just adjourning it so we can get the discovery.
I'll adjourn it February 5th. 2026, 9 a.m. bond continued. Thank you.
Thank you, Your Honor.
Court calls case people versus Carla Bordine.
Ashley Feltus for the people.
Here for Carlos.
Bordine.
Yeah, Your Honor, apologies. I think earlier the court adjourned her hearing to February 5th, I understand, to so that it's held with co-defendants.
Through all of the discovery. Is she here?
She did leave. I think she understood that the case had been addressed and that it was adjourned until February 5th.
Her co-defendant was called, Mr. Killowald's
Yes.
client. She may have misunderstood.
Yes, yeah, and that's apologies. I didn't.
But
correct
she
that.
was here,
She was here. She was present.
and we adjourned that to February 5th.
Yes, Your Honor.
Probable cause conference will be adjourned February 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Case People versus David Brown.
Prosecuting attorney, behalf of people.
Assistant Public Defender Chelsea Regil with on behalf of David Brown, who approaches. Come on up, Mr. Brown.
Mr. Brown is out of town. No, he's here.
State your name.
David, thank you. Trial.
What are we doing?
I'm asking to adjourn. I didn't have an opportunity to speak with Mr. Brown before court today, so I'd like to go over discovery with him.
January 29, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case of the People versus Nathan Burgess.
Assistant prosecutor.
This is the one. Who's on this? Let's go.
Let's go, let's go, let's go.
Your Honor, Stephanie Cannon, on behalf of my client standing in for Mr. Rebo. Could you please state your name for the record?
Nathan Burgess. I have before me a plea form. Is that what we're doing?
Yes, Your Honor, we're doing a plea in this matter.
The plea form indicates that the defendant will be pleading no contest to 3 misdemeanor charges. Count 5 of larceny, 200 to 1,000. Count 6 of false pretenses, 200 to 1,000. And count 7 false pretenses, 200 to 1,000. Upon his successful those are all 1-year offenses. On his successful no contest plea, counts 1 through 4 would be dismissed. That's the court's full understanding of the agreement.
That is my understanding, well.
Your Honor, that is our complete and full understanding of the agreement.
May I have him sworn?
Raise your right hand. Do you solemnly swear the public testimony you're about to give the whole truth and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Nathan Burgess. Sir, it is this court's understanding that you're going to plead no contest to 3 misdemeanor charges. Is that your understanding? Yes, sir. Says, first of all, to count 5, larceny, 200 to 1,000. That's a misdemeanor punishable by up to 1 year, $2,000 fine plus court costs. You understand that? Yes, sir. And also 2 counts of false pretenses, 200 to 1,000, constituting counts 6 and 7. All of these offenses are 1-year misdemeanors, are punishable by up to 1 year, $2,000 fine plus court cost. Fine could be increased at 3 times the value of the property, which is either the subject matter of the false pretenses or the larceny. If that's greater than $2,000, that would become your maximum fine. How you do? Understood. Understand that? All right. You understand what a no contest plea is? I do, yes. All right. 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest these charges. You understand that? Yes, sir. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. Understood. You understand that? Basis for the no contest plea?
Potential civil liability, Your Honor.
All right. Sir, I also have to advise you that while I'm taking pleas, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. You understand that? I do, yes. All right. Still wish to plead no contest? Yes, sir. To the charge of larceny, 200 to 1,000, how do you plead? Guilty.
No contest.
No contest. To the charge of false pretenses as contained in count 6.
Every time.
No
Every time.
To that same
Guilty.
charge as
Oh, no
contained in
contest.
count 7, how do you plead? No contest. Now, you understand that by pleading no contest, you'll not have a trial of any kind. Understood. You signed an advice of rights form, is that correct? Yes, sir. Any questions regarding any of those rights? Yes, sir. Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form. I do, yes. You understand you're giving up your right to appeal of right? Yes, sir. Are you on probation or parole? No, sir. Has anybody promised you anything other than what's been stated here today to get you to plead? No, they haven't. Anybody threaten you or coerce you? No, sir. You're doing this voluntarily?
I am.
And of your own free will?
Yes, sir.
All right. Course has been provided and had reviewed Michigan Department or Eastern Michigan University report for their case number 255779. Any objection to the court having reviewed that report?
No, Your Honor.
No objection, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could have determined the defendant's guilt to these charges of counts 5, 6, and 7. Sir, I do have to advise you that if between the time that I accept your plea and the time of sentencing, you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
I do, yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
People are not.
I'm not aware of any, Your Honor.
And have I complied with the court?
People are satisfied, Your Honor.
The court has, Your Honor.
Court will accept the defendant's plea of no contest to counts 5, 6, and 7. Counts 1 through 4 are dismissed. A pre-sentence investigation and report is ordered at 1482 probation. Sentencing will be
January 21st, 10 a.m. before Judge Barr.
January 21st, 2026, 10 a.m. before Judge Barr. Bond will continue.
Thank you.
Thank you. Court calls the case, People versus Jason Campbell.
Jason.
Assistant Public Defender Doffy, leave with Mr. Campbell, and I do have a green sheet. Your Honor, Mr. Campbell, to my understanding, was released to treatment from the jail, and I've not been able to reach him. I believe he was released to treatment within the past couple days.
Probable cause conference will be adjourned January 15th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls the case of the People versus LaShawn Charles.
And the order, Assistant Prosecuting Attorney for the People.
Stephanie Cannon on behalf of Ms. Charles, who should be appearing by Zoom, Your Honor.
Yes, I just need her to state her name.
LaShawn Charles.
LaShawn Charles.
You're asking for an adjournment.
Yes, Your Honor. Yes, I do believe we have probably come to a resolution on this matter. Some of the facts have to be nailed down, but I do believe
January
that the
29, 2026, 9 a.m. Bond continue.
Thank you, Your Honor. I'm sorry. It includes needing to get $1,000 into the court. I do believe
Can't do it that way.
Okay, thank you, Your
guys
Honor.
have to figure that out. Give you time to figure it out. Court calls
Thank you,
case
Your
People
Honor.
versus-
Happy holidays.
And to you. Court calls case People versus Deborah Collette.
Assistant Public Defender Jay Buck on behalf of Ms. Collette, who should be appearing via Zoom, Your Honor.
Should be, but is she?
You got her.
Where?
Oh, there she is.
There she is.
Ma'am, you need to unmute.
Second one on oxygen today.
Looks like she's still muted.
Yep.
Still muted.
Me?
There you go.
No, that's not her.
Damn it.
Who said that?
Miss Collette, can you unmute?
I'm trying to, Judge. I'm trying to. I don't know how to do it.
Who you call?
Miss Collette, do me a favor. Wave your hand if you can hear me. Okay, you're just asking for an adjournment.
I am, Your Honor.
All right.
I am asking.
Go ahead.
I am asking for 3 to 4 weeks. She is recovering right now, and she still has to provide me some information for purposes of mitigation.
Give her time to learn.
January 29, 2026, 9 a.m. Did you hear that date, ma'am? If you heard the date of January 29, 2026, wave your hand and let me know. All right, very good. Okay, your bond will continue. Thank you, ma'am.
Thank you, Your Honor.
All right. Court calls case of the people versus Corey Copeland Nash.
Can I get off here?
Thank you, Your Honor. Alex Warren Green on behalf of Miss Copeland Nash.
I have a plea form. Is that what we're doing?
Yes, Your Honor.
That's correct, Your Honor. Miss Copeland Nash, can you state your name?
Corey Copeland Nash.
All right. Plea form indicates she's going to plead guilty to the charge of attempted possession of a loaded firearm in a motor vehicle, the 1-year offense. Upon her successful plea to that charge count, that being count 2, count 1 would be dismissed. And that's the court's full understanding of the agreement.
That's our understanding, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear to put on the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name, please.
Corey Copeland Nash.
All right, ma'am, it is this court's understanding you're going to plead guilty to the charge of attempted possession of a loaded firearm in or upon a motor vehicle. That is a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Right.
You signed an advice of rights form, is that correct?
Yes.
Any question about any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on the form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Okay, of your own free will?
Yes.
All right, because you believe that you're guilty of this offense, ma'am?
Yes.
On the date of September 27th, 2025, at the location of Lake Point Lane near Briar Parkway in Pittsfield Township, Washtenaw County, State of Michigan, were you in a motor vehicle?
Yes.
All right. Did you have a pistol in that motor vehicle?
Yes.
Where was it located?
My purse.
In your purse? Okay. Ma'am, did you have authority to carry that weapon in that fashion?
Jenny's got a gun.
Not at that time. All right. Was it loaded?
The clip was in the purse as well, but it wasn't in the gun.
It wasn't in the gun. You don't know whether or not there was one in the chip.
So it was more than 2 actions away from fire.
There was not one?
There was not.
Okay, gotcha. All right. Ma'am, I do have to advise you, if I accept your plea and you commit misconduct between the time of my acceptance of your plea and the time of sentencing, commit misconduct as defined by the Michigan court rules, that the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, you're aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None from the defense.
And have I complied with the court?
Or satisfied.
And the defense is satisfied, Your Honor.
Everyone's satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
in front of
February 11th. Really?
Really?
2026, 9 a.m. That's before me. Bond continues.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Vasquez Davis.
Judge is getting some work done today.
Assistant Prosecuting Attorney for the people.
Assistant Public Defender Ben Dunaway on behalf of Mr. Davis, approaching the podium now. Your Honor, we just received an offer in this matter today.
Need some time to think it over.
Mr. Davis, come on up and would you state your name for the record, please?
My name is Vasquez Faison Davis.
Okay. So we just received an offer today from the people. I'd like to put that on the record and adjourn a couple of weeks for Mr. Davis to think about that.
Go ahead, put it on.
Your Honor, the offer for me to plead guilty to or no contest to 1 count of malicious destruction of property, 200 to 1,000. And the Restitution, we believe, is in the amount of $500
Is that payable at plea or sentencing?
after sentencing.
After, okay.
I'll adjourn this matter out January 22nd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you, sir.
Thank you. Keep your phone away till you get out of my courtroom. You know, yeah, that's funny. I'm serious.
Is that the 29th, Your Honor?
22nd.
22nd, thank you.
Oh, put your phone away. Looking for some other courts to see
What
if
was
there's
that
more
about,
action
man?
somewhere.
Was that a friend of yours?
This is a
What?
tough week to
Huh?
find
Is
trials.
he laughing at you? Why don't you take the phone? Huh? I just have to tell you everything. No, I'm done. Done. Court calls the case. People versus Eric L.C. Williams.
Assistant Public Defender Chelsea Vergil on behalf of Eric L.Z. Williams.
Your name?
Eric L.Z. Williams.
All right, what are we doing?
Your Honor, I'm asking for a very brief adjournment. I apologize. I did not realize Mr. L.Z. Williams was here today. There has been an offer, and I'd like time to discuss that with him.
Cause conference. January 29th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir. Court calls case of the people versus Ayana Fan.
And the water assistant prosecuting attorney to the people.
This is the other Fan.
Hi, I'm on Zoom.
Yes, you are.
Yes, you are.
Silly. Let's pick up a letter and then let's find out where it goes. What letter is this?
Are you wearing anything?
Sure, Danoa, you need to turn off your background noise, man. Ma'am.
Please tell me she's dressed.
Assistant Public Defender Ben Denowitz on behalf of Ms. Fenn.
Ms. Fenn, state your name, please.
Ayana Fan.
Okay, so we have a resolution in this matter, Your Honor. May I provide the plea form and the advice of rights to the deputy?
All right. The form indicates she's going to be pleading guilty to the charge of retail fraud, second degree. The 1 year offense. Upon her successful plea to that charge, count one would be dismissed. There is also a sentence agreement of probation under HIDA. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes.
That's court's full understanding.
Yes, Your Honor.
Ma'am, please raise your right hand.
Just your hand. Oh.
Oop, hold on. Wrong hand.
Yeah, your other right hand. There you go.
What? I don't know.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again, please.
Ayana Fan.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Can I be sentenced before you?
Can I get, Judge? I'd like you to do it.
Counsel approach, please.
Counsel approach, please. Does she know what's going on here? Any objection? I don't know. Can he do this? Can we go straight to sentencing? Is there any PSI that needs to happen first? Nope, that's not Burger King because we don't have any meat.
Go eat your food.
Ayanna Fenn is she wants it all right now. Arby's is not a sponsor. No, I wish they were. Arby's, man, I'm a big fan of their roast beef with Arby's sauce. As a matter of fact, is it lunchtime yet? Oh, it's almost lunchtime. This is why I'm thinking about. Where'd you go? Oh, she moved. Kimberly's just hanging out, promoting Tax Shield. How much she gets paid for that, I don't know. I think we have a prank call. Hang on. Hello?
Yeah. Ma'am, at this time, what I'm going to do is I'm going to stop the plea. I'm not going to take your plea at
Hello?
this point in time.
Hello?
And I'm going to adjourn the probable cause conference out to January 22nd,
Good morning. My name is Evelyn. I'm calling from Pure Life Services.
26
as a
at
follow-up
9
about the
a.m.
early access
I was going to go ahead with your plea
get
despite
in
the
the
fact that you weren't
Utah
supposed to be
final
appearing via
expense
Zoom,
plan
but now
for all
you have a
Utah
question
residents.
regarding the
Have you
sentencing
received it?
judge, and I'll let you
Hello?
talk that over with your attorney. We'll obtain all the paperwork, but I'll put it on the 22nd. Thank you.
As you might know, we've put together
Email
a
or
new.
call us instead. Thank you.
Okay, thank you.
Court calls the case, People versus Robin Finney.
The water assistant prosecuting attorney for the people.
Assistant Public Defender Jay Bellinger on behalf of
Robin
Ms. Finney,
Finney's
who
back.
should be on Zoom, Your Honor.
He's got two.
Yes, Your Honor.
Had two
Oh, there you go.
cases.
Okay, state your name, please.
Yes, Your Honor. Robin Finney.
Why you got that Spartan on your shirt?
My girlfriend gave it to me, Your Honor.
Should break up with her.
So I
You
have
asked for
to
better.
wear
You should ask for better gifts, like a turtle.
it. Yes, Your Honor.
Just saying. I don't know what that Spartan is. It made me feel uneasy.
Can I get a second?
What are we doing? What are we doing?
Your Honor.
This is Mr. Childers to now process case, so the order.
What?
No process.
I wasn't there, but it was extraordinary advocacy, I'm told.
And I would have to give some credit to Ms. Plumai as a result of that as well.
She wore him down.
She did. She did.
Wow.
What's going
I
on
just
in
I just
Jordan's
had the
life?
assist, Your Honor.
All right.
No process.
So
Drop the
if
charges.
they're in Spartan stuff, do I dismiss it? No.
If you, Your Honor, if you give me,
What I will do. What'd you say?
I could change my shirt, Your Honor.
No, you're good. Don't worry about it. We're good. Case is dismissed. Natalie
Yes,
Press.
thank you, Your Honor.
Thank you.
Thank you.
Have a good new year.
Thank you, Ms.
Happy
Penny.
holidays.
Good luck.
Thank you.
Court
Outta
calls
here.
case People versus Matthew Fitzgerald.
Robin Finney needs to
Assistant
turn
Public
off the
Defender Nicholas
camera.
Bukovich on behalf of Mr. Fitzgerald, who should be appearing via Zoom.
Yep.
Okay, there you are. State your name, sir.
Matthew Fitzgerald.
Whoa.
Okay, what are we
Great
doing?
audio.
At this time, Your Honor, will be asking for an adjournment to complete some pre-negotiations. I do have a green sheet.
Probable cause conference, all January 22nd,
What are we looking at in
2026,
Jordan's?
9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, sir.
Thank you.
Have a good one.
You do the same. Court calls case of the People versus Brandy Graham.
Asli Bashir on behalf of Brandy Graham, who I believe she
He
may
is
be
on Zoom.
on Zoom, yes.
Ma'am, unmute. State your name, please.
Brandy Graham.
All right, what are we doing?
Thank you. We're requesting an adjournment. I did speak with Assistant Prosecuting Attorney Zenda, and I understand that the discovery is being sent over. It may have been sent over today.
January 15th, 2026, 9 a.m. Bond continue.
Thank you.
15th. Court calls case of the People versus Joseph Hafner Cantor.
Alex Warren, Green on behalf of Hafner Cantor.
Here, Your Honor.
Can you state your name?
Joseph Hafner Cantor. All right, what are we doing?
Your Honor, we're asking for a preliminary examination at this time.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the 13th. Preliminary examination in person, January 13th, 2026, 9 a.m. before me.
Where?
Bond continued. Thank you.
I think the last time we were here was December the 4th.
Pardon?
Last time we were here was December the 4th. I have a violation dated December the 9th. Bond violation.
And we are in receipt of that, Your Honor. I did review it with my client.
You have a bond violation? I do. Behind that, I need these in the front.
So Your Honor, it does seem to indicate,
We were here last on what day?
I thought December the 4th.
Yes, I have December 4th, and I've got,
So it does appear that these tests were in the interim period between the last time we were here and this
Mr. Allen.
with positive alcohol blows on the silver leaf.
Mr. Allen.
We've got a positive.
Mr. Allen moves into position.
On December 8th. And then missed tests really through the 9th, early into the morning. So the 8th was at 11:37 p.m. 0.07. And then 04, probably the same alcohol, maybe a little bit more, by 8 a.m. that morning. So some 8 hours later, he's still blowing numbers. Except that then a little bit later, it popped up and then went down. So it looked like he was continuing to drink. Then the worst thing happened.
And the worst thing.
They spoke with him.
And
he said he didn't have any alcohol.
And Your Honor, I believe Mr. Hafner Cantor is changing his position on that now.
Really?
He did appear on the same day that this violation report was submitted. He appeared before Judge Frushauer to be arraigned on a misdemeanor OWI. The misdemeanor OWI date of the alleged offense predates this case. I think it was just authorized later due to lab results. But nevertheless, he appeared for arraignment knowing that this violation was there, and it was addressed at that time by Judge Frushauer, who had him taken into custody with a $5,000 10% bond. I think the condition of that bond
on this case,
he was taken into custody at the time of his arraignment.
You're saying two different things to me. Her taking him into custody at the time of the arraignment is one thing. If she's taking him into custody on this case, that's a different thing, and not something that I see in this file.
And you're correct. What happened was, after the court considered this bond violation and received the report from his tether agent, bond was set in the amount of $5,000, 10%, with the condition that he be fitted with a scram tether before that bond shifts to a personal bond. So he was fitted with a scram tether. He remains on that scram tether since December 9th, and I don't believe he's had any violations. Mr. Hafner Cantor is employed and has stable housing with his employer in Saline. Your Honor, I would ask the court to consider continuing his bond, because I think him being on a scram tether is kind of the constant reminder he needs not to drink. I will note the present offense. I don't believe there are any alcohol related allegations, but of course he does have a misdemeanor OWI, and he admits he has a drinking problem.
Mr. Allen's in position. He's got some work to do. I think it will
Yeah, but
involve
this
custody.
Response from the people.
The people are glad that he has now a scram order on the OWI case that's pending before Judge Frushauer. However, it's still a violation in this case to have been drinking. I'm not sure. I know the court generally will issued warrants pretty quickly when these things sort of come through. I'm not quite sure what happened here, but no matter what, it does.
Was there a warrant issued on this one?
It does appear to the people that alcohol is a significant problem for the defendant. It appears that SoberLink is not working. So I would ask that the court, at the minimum, order the scram in this case as well.
Did he take the ETG?
Doesn't look like it from this report.
I did not give you one.
So there was a warrant issued on this one, okay.
Okay.
Is it still out?
For Mr. Hafford?
Yeah.
Okay.
No, I do not see that warrant.
Oh, you do not see that
I
one.
do not see, no. So he was, the report says, I advised him to report to community corrections for an ETG urine test by end of the day. This is on 12/9. He said he had court and only had transportation there, doesn't have any money to take the urine test. I advised him a violation would be sent, and I was affording him the opportunity to take ETG test to provide results with my report if in fact he was not drinking. And I just confirmed with Mr. Cook. Mr. Cook informs me that the defendant had a positive BAC coming into court. I'm not sure if that's related to this violation report or if it was actually going to court, but it does all appear to be on the same date, that December the 9th sort of time frame.
So when did he appear before Judge Freshour?
It looks like December the 9th.
That's correct.
What time?
9-ish in the morning.
9-ish.
So she may or may not have been aware then.
She was aware, she remanded him. And
But was she aware that he was intoxicated?
Mr. Cook's note indicates, and his communication to me indicates that he had a positive BAC coming into court. I'm assuming that means he was blowing numbers at court.
He was blowing numbers.
And I know that community corrections was there.
Okay, I'm pretty much done. I mean, you drank coming into court. You drink in violation of my bond. I saw you 4 days beforehand. And no,
May I speak?
we don't do that. Say whatever you want.
Your Honor, I think what Mr. Hafner kind of wants the court to consider is that since this string of events leading up to the court date on December 9th, I think he has pivoted and changed his position from denying
So let me
his
get
problem.
this right. You're telling me that all of a sudden everything has changed. On December 8th, he's drinking. He's drinking well into the morning on December 8th. He has to appear in court, can't stop drinking, and then ends up at court that day. He talks to community corrections, I think, on that same day and just is absolutely lying to them. And somehow between now and that date, he has made a certain epiphany has occurred.
An epiphany.
And he's made some miraculous transformation. Is that what you're telling me?
Bit of aha moment.
Your Honor, I understand the court's concern. Mr. Hafner Cantor, when were you released from the Washtenaw County jail? Was it the following day or this?
I was there for a week. I think I was released on the 19th or the 18th.
So, Your Honor, he's strung together 10 days on a scram tether with no issues whatsoever. And I think that's what he wants the court to consider in reassessing bond here. I would ask the court to continue his bond based on the fact that he's come into compliance since being placed on the scram tether.
He's in violation on my case, goes to another court,
Violates
drunk.
that one.
And Your Honor, I would like to correct my record I made to make sure that it's accurate. Mr. Cook has let me know that he doesn't know if the defendant was individually tested at the court, but because he had the 0.04 30 minutes before the judge saw him, Mr. Cook's note was that he was drinking. So I apologize if that was confusing at all. I just want to make
So he wasn't breathalyzed at court.
now that Mr. Cook is aware.
Where
But
it's because it was 30 minutes before, there was an assumption that, which is a good assumption.
it's pretty fair, yeah.
Anything else?
Your Honor, I know Mr. Hafner Cantor's been in constant contact with his community corrections agent, and I know that his 3-year-old daughter, who he takes care of, is his biggest concern. I think he was dealing with some stress regarding a custody situation with respect to his daughter. And
He's violated my bond. And then absolute disrespect showed up at another court, still under the influence of his drinking event that violates his bond in this case. And he's appearing at that time on an OWI. And he's not in any treatment.
Yeah, the way the judge puts it doesn't look
Anything
good.
else?
Nothing for the
nothing further, Your Honor.
Bond revoked, defendant's remanded.
Your Honor,
Yeah.
and
The 13th is.
and with respect to that date, he does appear in district court on that same date. I'm not sure if the court wants to move it or if the jail would be able to accommodate that
District court where?
for the OWI case.
Well, he wouldn't exam until much later.
Which judge is the exam?
Me.
Thank you, Your Honor.
Court calls case People versus Nicholas Harding.
Assistant Prosecuting Attorney for the People.
Assistant Public Defender Dobby Lieb on behalf of Mr. Harding. Mr. Harding, could you please tell the court your name, sir?
Nicholas Harding.
Alexander on behalf of.
And Your Honor, we are requesting adjournment of this matter. We have received an offer that Mr. Harding is considering. I'd just like to have him to have some time to reflect.
January 15, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
I guess the Arby's extra large is out of the
Court calls
question.
case of the People versus Daniel Hardy.
Assistant Prosecuting Attorney for the People.
I
got too many
thought about it. Yeah.
Assistant Public Defender Ben Dunaway on behalf of Mr. Daniel Hardy, who should be on Zoom.
Mrs.
I am
Arby brought
here.
me a salad.
Okay, Your Honor, we are
Who's
prepared
here?
to waive exam today. We do have an offer. We'll be taking advantage of it, circuit court. If we could ask the prosecutor to place that on the record.
The offer is that Mr. Hardy pays half the restitution, which is approximately $1,000 prior to the plea. Then he can enter a plea under 771(1) deferred. That is contingent on him paying the remaining amount of restitution to take advantage of that.
And Mr. Hardy, do you understand that? And do you wish to waive your exam to go to circuit court to take advantage of that offer?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand that you will not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
We will stand mute. We have the formal reading.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
February 25th at 1:30 before Judge Conlon.
February 25th, 2026, 1:30 before Judge Conlon. Bond will continue.
Thank you, Judge.
Thank you. Court calls
Thank you.
case of the People versus Robert Harris.
Assistant Prosecuting Attorney for the People.
Asli Bashir on behalf of Robert Harris. Mr. Harris,
You're requesting an adjournment.
yes, for further negotiations, Your Honor.
Your Honor, we briefly approached it.
Very briefly.
I'm just going to say, don't try it till don't knock it till you try it. Hydrocortisone. I keep it here safely so it's away from my toothpaste. I did get some, not a sponsor, Hidden Valley Ranch dressing, which I'll probably use too much of on my salad. But it's almost time for lunch. I was just waiting to see if our friend who got a little reprieve and got to talk to his lawyer to figure out what his decision is, if he's going to do it. So, yes, Mrs. R.A. loves this.
I will adjourn this matter. Probable cause conference to January 29th, 2026, 9 a.m. His bond will continue. He paid. money to 15th District Court, which they accepted apparently. So I don't know. The deal is, but we need an order.
Okay. Thank you, Your Honor.
Alan's relaxed. He's
Court
also
does call the
center
case
square.
of the people versus Ardashir Hassani.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Hassani, who is standing to my side. Can you please state your name for the record, sir?
Yes, Ardashir Hassani.
All right.
At this time, Your Honor, I'll be asking for a brief adjournment to finalize some plea negotiations.
Probable cause conference, January 15th, 2026, 9 a.m. I'll need a green sheet.
Your Honor, we'll be sending over a stipulation to travel where my client will be traveling from January 5th to January 20th. So would it be possible to get the 22nd date?
Where is he going?
You're going to Canada, correct?
Yes.
Going where?
Canada.
Canada?
Our fellow finished
the whole place? Where in Canada?
Toronto.
Toronto?
Yes.
Oh no. Things happen in Toronto. Beautiful city. Love the place.
Yes.
For that long?
For 2 weeks, yes.
Not right about this. I'm not sure. January 29th.
Thank you, Your Honor.
And I'll wait to get the.
Yeah, that should be being sent over shortly.
Pardon?
That the order should be being sent over shortly.
All right.
Because we here in
Thank
Canada
you. Happy New Year.
hate you.
And to you.
And
Court calls the case.
for
People
bad things for
versus
you.
Daniel.
Because
Milan.
we hate you.
Ashley Feltus for the people.
Is that Mr. Hammond, Your Honor?
Milan.
Yes.
Search, unmute, state your name.
Daniel Heelan, Your Honor.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Heelan.
What are we doing?
At this time, Your Honor, we're requesting a adjournment for purposes of pre-negotiations. Mr. Heelan just got into treatment, so.
January 29th, 2026, 9 a.m. Bond continued. Thank you, sir.
And Your Honor, I'm also handing you the green sheet for Mr. Hassani's file as well.
Nice if I had them at the time that the case is called.
Yeah, I'm actually in treatment right now.
What?
I'm in intake. I'm in treatment right now, Your Honor.
That's what I said, Mr.
We already got that.
Oh, okay.
We'll see you on the 29th. Thank you.
Thank you, Your Honor.
Court calls case people versus Robert Jameson II.
Ashley Feltus for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Jameson, but not with.
Not with.
Not with.
Bench warrant will issue bond 10,000, cash surety. The warrant will issue immediately. Court calls case of the people versus Cyrano Johnson.
Assistant Prosecuting Attorney for the people.
Stephanie Cannon on behalf of Mr. Johnson. Mr. Johnson, when you're at the lectern, please state your name for the record.
Cyrano Johnson. How are you?
Thank you, sir.
And Your Honor, I do believe we're close to
you
resolution
wore a
on this
tux.
matter. However, I would just ask for a brief adjournment, hopefully for a plea.
Bow tie and where's the cummerbund?
January 29th, 2026. 9 a.m. bond continued.
You say January 26th, Your Honor?
29.
29th, I was so close.
I'm glad you were listening.
I-
All right.
Oh.
We'll do it then. Thank you.
I'm 60.
Oh,
Thank you, sir. Better leave Mr. Johnson alone. Court calls the case. People versus Jalen Johnson.
Assistant Prosecuting Attorney for the people.
Brian Boyd on behalf of Mr. Johnson. Working, Your Honor. Your name for the record.
Ayden Johnson.
Judge, I'm asking for an adjournment to try to obtain body cam footage from the police that I know Mr. Overwater is working on, as well as I'd like to do some investigation work within my office.
January 29, 2026, 9 a.m. Continue.
Do some investigation work within my office.
Court calls case People versus Gregory Jones.
Prosecution on behalf of Jones. Your Honor, we are requesting an adjournment for further negotiations in this matter.
Probable cause conference, January 15th. 2026, 9 a.m. Bond. Court calls case of the People versus Jimmy Lips.
Water Assistant Prosecuting Attorney.
Jimmy Lips. A lot of
Brian Bowen,
changeover in court right now.
Lips is approaching.
Your name, sir?
Jimmy Lips. Your Honor, I'm asking for an adjournment in this matter as well, looking to get surveillance footage from the store. I know Mr. Overwater is working on it.
Probable cause conference, January 29th, 2026, 9 a.m. Bond. Continue.
Thank you, Judge. Yeah, give me a minute. I'll give you a notice for that.
Court calls case of the People versus Austin Lobestall.
Water Assistant Prosecuting Attorney for the People.
Brian Bowling on behalf of Mr. Lobestall. You should be present on Zoom.
Lobestall, can you state your name, please, sir?
Austin Lobestall.
All right. Since court's understanding, I have a plea form in front of me that indicates he'll be pleading guilty to an added count 2 of larceny by conversion 200 to 1,000 to 1 year offense. Upon a successful plea to that charge, count 1 would be dismissed. Defendant is agreeing to pay $5,000 in restitution. There's a sentence agreement of deferred sentence under 771.1 under the condition that restitution is paid in full. That's the court's full understanding.
That is correct, Your Honor.
That's my understanding as well, Judge.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes.
State your name for the record.
Larceny by
Austin
conversion.
Lobestall.
All right, sir, it is this court's
something like a
understanding
rental
that you're
car?
going to be pleading guilty to the charge of larceny by conversion 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased 3 times the value of the property taken. If that's greater than 2,000, that would be your maximum fine. You understand that, sir?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
They signed it on my
You had your
behalf.
attorney sign one on your behalf?
Yes.
After going through it, do you have any question regarding any of those rights?
Nope.
Looking at paragraph 5, you understand also that you're waiving all of those rights on that form, including your rights that are your trial rights, which are contained under paragraph 5. You understand that?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
I am, but I was not when this
You
incident
weren't at
occurred.
the time that this happened, is that correct?
Yes, that is correct.
I can do it if
Has
you
any-
can put her in the diaper team.
Really? Got it. Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
Did someone in a muscle suit walk
You're doing
behind
this
Keith Moore?
voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes.
July 1st, 2024, at the location of 14655 Hines, or Hinsey, in Manchester Township, Washtenaw County, State of Michigan. What do you do on that date that makes you think that you're guilty?
I took a deposit on a job and I did not complete the job and did not return the money.
And it was a contracting type of work?
Yes.
All right. And the funds that you took, you converted those funds to your own use?
Yes.
And the amount was in excess of $200 that you took?
Yes.
Okay, sir, if I accept your plea, I need you to understand if you commit misconduct between the time I accept your plea and the time of sentencing, that's misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
I am not.
And have I complied with the court rule?
The people are satisfied.
I agree, you have.
Court will accept the defendant's plea to count two. Count one is dismissed. The pre-sentence investigation and report is ordered at 1484 probation. Sentencing in this matter will be February 3rd, 2026, 9 a.m. before Judge Freshour.
May I address one issue regarding bond, Judge?
Yes, please.
Mr. Lobestall would like to go to Ohio with family.
For what reason?
They own a cottage down there that they need to do some.
In Ohio?
Yeah.
They have those?
They do.
Okay, go
apparently. From January 3rd, returning on January 7th. So we'd ask for your permission to allow him to do.
To go to Ohio.
To go to Ohio.
Mm-hmm. On purpose.
Apparently.
Yeah. What part of Ohio?
Near Athens.
Oh.
The people do not object if Mr. Lobsdale wants to punish himself prior to sentencing.
Well, if there's no objection, I guess I'll let him go.
Awesome. Thanks.
What do they have
Thank you,
against
Ron. We'll
Ohio?
continue. What are the dates you're going?
January 3rd through January 7th.
3rd through the 7th?
Correct.
You'll take care of that. All right. Thank you.
Thanks.
Thank you.
Travel safely.
Thank you.
They don't even have roads. That's what I hear. Do they? They do?
Yeah.
In Ohio? Oh, you're from Ohio. You are, aren't you? I mean, the other side, kind of, because you're from like Cleveland area, which nobody claims. Yeah, but do we really listen to that? No. Okay, good. Nice chat. Court calls case, People versus Quadir Man.
Assistant Public Defender Ben Benowitz on behalf of Mr. Mann, who is standing to my right. Sir, would you say your name for the record, please?
Quadir Man.
Thank you.
Your Honor, we would like to set this matter for exam.
All right. Discovery is complete.
Discovery is complete.
People had their witnesses available the 13th. Preliminary examination in person, January 13th, 2026, 9 a.m. before 15th District Court Judge. Yes.
Your Honor, it came to my attention in looking at the defendant's jail calls before he was released and after he was arraigned. He made 50 calls to the victim from his PIN to her listed number after being arraigned. And that doesn't count 50. The day that he was arraigned after he was arraigned. That only encompasses days exclusively after he was arraigned. He calls her 50 times. So I have concerns given that also to Raymond, the magistrate indicated his concerns that he will not follow court orders and that he would go back to contacting the victim as soon as he was released. And it seems that he didn't even do that prior to being released. He did it while he was still in custody. So I have concerns given now that he is out for safety. I also have concerns given the facts of this case in which his grandmother is the person who reported the crime after she awoke to blood-curdling screams from the victim and felt she had to call 911 after hearing the victim being slapped. So I have concerns for safety given that he was contacting her excessively from jail.
When was he released?
I'm sorry, could you?
When was he released from jail?
I believe it was the 26th and he was arraigned on the 24th after being arrested on the 23rd. Could I attempt to respond, Your Honor?
Go ahead.
My response is primarily based on the facts of the case. This complaining witness stated she was not assaulted. The grandma did not witness any sort of assault. As the prosecutor told you, she said she heard something. So there's no witness that actually witnessed an assault. So then, Your Honor, the police say he's laying on a mattress with a blanket on him, which we would commonly call sleeping. The complaining witness tells the police he has a head injury from falling down, okay? So he's sleeping and has a head injury. The facts of the felony charge in Washtenaw County in 2025 is that he had to be told 3 times to turn around and 4 times to back up. And that's a felony. And now we want to revoke his bond, which is basically a due process violation because you take away his trial right. His trial will be in about 8 months.
Why am I taking away his trial right?
Because if he's incarcerated, then it's make a get out of jail plea. I mean, he's talked to.
It's not, counsel. And quite frankly, this court resents that you even make that argument that this court will be involved in violation of anybody's due process rights. He's given conditions. If he does not follow those conditions, he pays the consequence.
I agree. I just indicate to the court, I don't think the person that the condition is regarding wants that condition. She didn't want any of this. And then
there's a way in which that's taken care of, not by him continuously calling. He knows he's not supposed to be
I mean, Your Honor, he's 19 and it's Christmas. I just asked the court to give him a chance until we have a date on the 13th. I mean, if this witness says he's contacting her currently, you know, she comes to court on the 13th and tells the court there's a bond violation. I clearly don't have an argument to that, but if the court would let him stay out to the 13th and he's not going to contact.
I don't know what he's doing now. I mean, that's what part of the problem is. Part of the problem is that, and by the way, not only is your client entitled to due process, but the people are entitled to due process. Everyone is entitled to due process, and it is my job to make sure that it happens. If I believe for whatever reason that he may be interfering with the people's due process rights to fairly present their witnesses and have their witnesses present, then I'll take action, which I'm about to do now. Right now, his bond is revoked. Defendant is remanded. Thank you. Yes, and his phone privileges while in jail are revoked. Put that, can you?
Would the court only revoke as to the 2 persons with no contact orders?
I'm revoking his phone privileges.
Okay, thank you.
Court does call the case, People versus Kelton Martin.
That was a non-captive people, Your Honor. Stephanie Cannon on behalf of Mr. Martin, Your Honor, who is present. Mr. Martin,
hands out of your pocket.
Well, I apologize.
could you please state your name for the record, Mr. Martin?
Dr. Martin.
What are you doing?
Your Honor, I'm asking for an adjournment. This is another case where I don't have discovery.
January 29th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case, People versus Keith Moore.
Assistant Public Defender Nick Bukovich, but on behalf of Mr. Moore, who should be appearing via Zoom.
Ooh, somebody's lighting up.
Keith Moore.
Yes.
Turn on your camera. State your name.
Keith Derek Moore.
Thank you. What are we doing?
Yeah, on today is a day set for competency review as well as a PCC.
Probably cause hearing.
Is the court in receipt of the competency finding?
Yes.
I am now, I think. From
it's dated on November 24th, 2025. So it'd be after the last
November 19th.
I'm sorry, November 19th. I'm sorry.
Yes, that's when it was completed. The defense counsel received November 24th.
I apologize, Your Honor.
No, it's okay. All right.
It does find that he is competent to stand trial.
Yes.
Would stipulate to its entry and have no further evidence.
Yes,
other
another offense would also
dismissals?
stipulate to his entry, have no further evidence, and be requesting for adjournment of the PCC for the purposes of negotiation.
All right. Court having reviewed that report, court would find that the defendant is competent to stand trial, specifically that the defendant can understand the nature and the objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent, and I've signed an order to that effect.
In Your Honor, in setting the date, I have been in contact with my client's caseworker. He does have a civil court date on the 22nd, which I know is a Thursday. So I'll be asking for a PCC date that would align with that court date down at the 22nd Circuit Court.
29th, January 29th, 2026, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Your Honor, you said I missed it. Does the court have a copy of an order?
Yes.
Oh, perfect. Thank you so much.
Excuse me, Your Honor.
Yes.
What's the civil court case?
What is what?
What was my civil? He said I had a civil court case.
Yeah, I have no idea.
Speak to your caseworker, Miss Bishop. She was the one who reached out to me to let me know about the court date, so you can so we could schedule this one outside of that. Okay.
Okay, thank you.
I was asking for
Burko's case, People versus Melinda Olivo.
Stephanie Canna on behalf of Ms. Olivo, who is approaching. Ms. Olivo, when you are present, please state your name for the record. Melinda Olivo.
Hands out of pockets.
And Your Honor, we're asking for an adjournment. On this case, I have no media. So I would ask.
You have no media?
No, I have none.
Probable cause conference, January 29th, 2026, 9 a.m. Bond continued. Calls case of the People versus Micah. Is it Addison?
Signature on behalf of Micah Addison, who appears on Zoom. And
it's
Your
Mika
Honor.
Addison.
Oh yeah, I'm sorry. Oh, Mika Addison. Apologies.
It's what?
It's pronounced Mika Addison.
Oh,
sorry.
You just wanted to yell at me, didn't you?
No, I really didn't.
See, if I had said Micah, if I had said Mika, she would have said it's Micah. No, I know what's going on here. I know when I'm being set up.
I hate my name sometimes.
That's my fault, Your Honor.
No, it is your fault. You should have known.
Oh, I addressed her by her last name, and I just haven't used the first name.
Oh, you just skipped the first name because you didn't know.
Well, I just.
That's what I'm going to do.
Ms. Anyway, I should have checked the first name. We're requesting an adjournment for 3 weeks just to provide some mitigation to the
prosecutor's office. All right. Probable cause conference in this case. I'll adjourn it to November 29th, or not November, January 29th, 2026, 9 a.m., which it seems like I'm setting that far. Court does call the case, People versus Riel Page Pollard.
Assistant Prosecuting Attorney for the People.
Assistant Public Defender Davi Lieb on behalf of Mr. Page Pollard, who appeared via Zoom.
Here. Pardon? Sir, unmute, state your name.
Riel Page Pollard.
And Your Honor, we're requesting an adjournment. I did finish receiving discovery yesterday.
Probable cause conference, January 22nd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case People versus Hubert Price.
Assistant Public Defender Chelsea Reveals with and on behalf of Hubert Price, who should appear via Zoom.
We don't have them.
I apologize, when I talked to him yesterday, he told me that he was fully versed on how to use Zoom. Would you mind passing it so I can call him?
Is it him? What's your name?
Hubert Price.
Your Honor, we are asking to adjourn this case for media discovery.
Discovery issue, January 29th, 2026, 9 a.m. I need a green sheet, bound continue.
Thank you.
Court does call the
Happy
case.
hol-
Pardon?
I said, thank you and happy holidays.
And to you, sir. Thank you. Court does call the case. The people versus Joanna Reed.
Assistant Public Defender Jay Bellinger, on behalf of Ms. Reed, who is on Zoom, Your Honor. There she is.
Oh, Ms. Reed. This is a competency.
That's correct, Your Honor. I did submit a finding and order to the court. The defense has no other, we would stipulate to the findings. We have no other evidence to present.
Also, so stipulate no further evidence.
All right. Based upon a review of that report, court would find that the defendant is competent to stand trial. Would further indicate that the defendant can understand the nature and the objects of the proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent, and I have signed that order.
Thank you, Your Honor. As to the PCC for this matter, Your Honor, we are asking for a new date. It looks like we're going to be able to reach resolution on this.
So January 29th, 2026, 9 a.m. Bond continues.
Thank you very much.
Thank you. Thank you, ma'am. Court calls the case, people versus Connor Rice.
We're getting to the edge of the docket here. Judge checking his watch. Wants to go to lunch.
And Alex Warren Green on behalf of Mr. Rice.
My salad was delicious, by the way. Thank you, Mrs. R.A.
Her name?
Connor Rice. Your Honor, we're asking for a preliminary examination.
Discovery is complete.
I believe so, Your Honor.
People be ready. Well, people have their witnesses available the 13th. Preliminary examination in person, January 13th, 2026, 9 a.m. before me. Bond will continue. Thank you.
Thank you. Thank you, Your Honor.
Court calls the case of the people versus Montrez Root.
And Alex Warren Green on behalf of Mr. Root.
Where's his pants?
I got in from Phoenix, so I don't have them. I live in Phoenix, so I don't have them in my car.
Sorry.
It's all right. My bad, sure.
Did you fly?
Yeah, I flew in and then got here on right before Christmas, and then
Didn't the people on the airplane tell you what the temperature here was? Even before you left Phoenix?
Well, I didn't. I came to I turned myself in when I got here because of the Warren situation. So I was just trying to.
But what about the weather situation?
Oh,
he'll have a pair of pants at the next court date.
No, you know what? If you do that and you're out there in that weather and that, have at it.
No, that was one of the things I was going to ask today.
What, for pants?
No, if it was a possibility, if I could go back to just get some of my clothes for my next court date, so I'm not looking crazy. If you would allow me to
go back where?
Phoenix. That's where I reside. That's where I live.
Oh.
Yeah, pants.
Do you have long pants?
Yeah, I got a lot.
Oh, okay. I didn't know.
You're gonna fly back to Phoenix to get a pair of pants?
Your Honor,
Isn't
with
it cheaper?
respect,
Just
he knows
to
you can buy them here too.
Yeah, save some money.
Never mind.
I'll point them in the right direction.
I'm
Amazon.
Not my business. Back to Amazon and bring them to you.
Mm-hmm. I just said that, Judge.
Never mind. Again, not my business.
Not
what
a
do you want to
sponsor.
do?
With respect to the probable cause conference, I would ask for an adjournment so that we can complete discovery. And I understand that my client is potentially going to be retaining a private attorney. Mr. Vincent, I did this morning already. I just have to stop by his office before I head to where I'm going. But I already did.
Grab a pair of pants.
Does he know you're in shorts?
Yeah, we spoke out. We spoke in the hallway when
What
we
did
talked.
he say?
He was ready for me. He said he was going to try for me to get back so I can get.
No, what did he say about the shorts?
Oh, he didn't say nothing.
He did?
Okay, yeah. He didn't care. He was just happy that I was paying him.
Yes. yeah, that's pretty much Michael for you. So you are retaining Mr. Vince.
Yes, sir.
So I'll grant the adjournment, and that may be why Amanda's hanging around. What did we set as other things, Jim?
I believe the 29th.
29th. Okay, can you get to Phoenix and get back?
Yes, I can. I will. I'll have a nice suit on when I come back.
Oh, it's okay. I don't care. That's all you brought?
Well, I got picked up in Phoenix, and instantly when I got to Phoenix, I had to wait in the county jail there because I didn't have a bond until I got here. So I had to wait there, and this is what I was driving, having a good time in shorts and hoodie. I didn't think I was going to jail.
No, I'm saying this out of genuine concern because he could walk out of here, his legs fall off.
Right. No, I have plenty of clothes back home.
Probable cause conference, January 29, 2026, 9 a.m. I will continue.
Thank you, Your Honor.
Tell Vincent buy the man some pants. All right. Jeez. Clerk calls the case, People versus Thomas Sharon. Or Sharon.
Public Defender Chelsea Virgil is on behalf of Thomas Sharon, who I have not been able to get in contact with.
Thomas Sharon. Bench warrant will issue for defendant's failure to appear, bond set in the amount of 10,000, cash surety. That warrant will issue immediately.
The case of the traveling for pants.
Court calls the case, People versus Ashley Shepard.
Stephanie Cannon on behalf of Ms. Shepard, who should be appearing by Zoom.
Oh, she is. Sort of. Yes. North Face, not a sponsor.
Shepard, can you state your name?
Ashley Shepard.
We have reached an agreement in this case. It has not been reduced to writing yet, so I think we're just looking for a short adjournment to get that done.
Your Honor, that is correct.
Probable cause conference will be adjourned January 15th, 2026, 9 a.m. Bond continue.
Thank you so much. Ms. Shepard, I will call you.
Thank you.
Court calls the case of the People versus Jordan Smith.
Jordan, you're up.
Assistant Public Defender Jay Bellinger on behalf of Mr. Smith, who appears via Zoom, Your Honor.
He just was sitting
Mr.
there
Smith, can you
ready
please
the
state your
whole
name?
time.
Jordan Smith.
Is that a dress?
And Your
in the
Honor,
closet?
we are just asking, we have reached a resolution in this case that's contingent upon entering the mental health recovery court. So I'm just asking for some time to get the application done. I will have that to the court by the end of the day. However, it may take some time, obviously, for the.
Right, on the other part of it, January 29th, 2026, 9 a.m. Bond continue.
Thank you very much.
Thank you, Your Honor.
Thank you, sir. Court calls the case.
Alan
People versus Joseph Smith.
People.
Ashley Bashir on behalf of Joseph Smith, on both the matter ending 1343 and 1915.
Joseph King Smith.
And Your Honor, this matter was previously adjourned to review discovery with Mr. Smith. We're requesting an adjournment for further negotiations or for negotiations on the matter to 3 weeks if possible.
Pardon?
3 weeks for both matters if possible.
Probable cause conference, January 29th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
We're almost at the end of the docket.
Okay, so the People versus Taj Smith.
Ashley Bashir on behalf of Taj Smith, who appears on Zoom.
State your name, please.
Taj Smith. In Your Honor, it appears that there may be a conflict with our office in this case. The court would not have received documentation. It was very recently identified. We're requesting a 2-week adjournment just for new counsel.
Probable cause, January 8th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you.
Jeez. Barely made it to court. Couldn't be bothered.
Calls case of People versus Kimberly Stampley.
Kimberly from Tax Shield Services.
Assistant Public Defender Buckovich from Ms. Stampley, who is appearing via Zoom.
Hi, good morning, Kimberly Stampley.
All right. And are we doing the plea form?
Yes, we are, Your Honor.
So defendant is going to be pleading to 4 charges.
Yes, Your Honor.
Count 2 of operating with a high BAC, 180-day offense. Count 3 of operating without security, a 1-year offense. Count 4, fingerprint refusal, a 90-day offense. And count 5, attempted resisting and obstructing a police officer, 1-year offense. Upon her successful plea to counts 2, 3, 4, and 5, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor. I understand this will be no contest, please.
Yes, no contest, please. Is that a correct statement?
That's correct, Your Honor.
All right. Ma'am, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record.
Kimberly Stapley.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to 4 misdemeanor charges. The first being count 2 of operating with a high BAC. That's a misdemeanor punishable by up to 180 days incarceration at $200 to $700 fine plus court costs. The court could order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized or forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes.
All right. Count 3 is operating without security. That is a misdemeanor punishable by up to 1 year incarceration, $200 and a fine not less than $200 nor more than $500 fine plus court costs. You understand that?
Yes.
Also, that you'll be pleading to count 4, fingerprint refusal. That is a misdemeanor punishable by up to 90 days incarceration, a $500 fine plus court costs. You understand that?
Yes.
And also an added count 5 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand all of that?
Yes.
Do you understand what a no contest plea is?
Yes.
2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest these 4 charges. You understand that?
Yes.
The second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes.
Basis for the no contest plea.
Recollection, Your Honor.
All right.
Surprise, surprise.
Do you still wish to plead no contest, ma'am?
Yes.
To the charge of operating with a high BAC, how do you plead?
Are we in the bathroom,
No,
Alan?
no contest.
To the charge of operating without security, how do you plead?
No, no contest.
To the charge of fingerprint refusal, how do you plead?
No contest.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
No contest.
And you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You went over an advice of rights with your attorney and gave them permission to sign on your behalf?
Yes.
Do you have any questions regarding any of the rights on that form?
No, I just want to say that I submitted the fingerprints. So.
Okay. Do you have any questions regarding any of the rights that are on the form?
No.
You understand that by pleading no contest, you're waiving or giving up those rights, particularly your rights contained under paragraph 5, your trial rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 24-11379. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these for charges. Ma'am,
Yes.
if between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would first of all not be entitled to withdraw your plea, and secondly, the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Court satisfied.
The defense is satisfied, Your Honor.
Court will accept the defendant's plea of no contest to counts 2, 3, 4, and 5. Count 1 is dismissed. A pre-sentence investigation and screening assessment is ordered at 14A1. Sentencing will be February 11th, 2026, 9 a.m. Bond in this matter with its conditions will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, ma'am. Court calls the case, People versus Sergio Staples.
People. Assistant Public Defender Davi Lebo on behalf of Mr. Staples, who I believe appears on Zoom.
Mr. Staples, state your name.
Sergio Staples.
What are we doing?
Your Honor, Mr. Staples would like to waive. We do have an agreement where upon waiver and offer to plead guilty to counts 3 and 4 under HIDA at circuit court would be available. I do have the waiver form in front of me, and Mr. Staples, may I sign this with your permission, sir?
Yes.
Sir, you're waiving your right to a preliminary examination?
Yes.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yep. Yes.
Yep.
People also waive their right?
Yes, ma'am.
Preliminary examination having been waived, defendant is bound over to circuit court on all 4 counts.
Your Honor, we acknowledge receipt of the information, waive formal reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial in this matter will be set for
February 25th at 1:30 before Judge Conlon.
February 25th, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you.
Court calls the case, People versus Brandon Thomas.
So what that?
Assistant Prosecuting Attorney for the People.
Assistant Public Defender Chelsea Ridgewood, with and on behalf of Brandon Thomas. Please state your name.
Brandon Thomas, Your Honor.
And we are asking to adjourn in this case for a plea discussion.
He's still testing positive?
For marijuana?
Yeah. You have a card?
I don't have a card, but I smoked before you took me to jail.
Oh, I know.
Yeah, so it's like,
so the
my
numbers,
levels will be lower for sure.
so the numbers will be going down?
Yes, sir.
You sure?
Yes, sir.
Because I can call over and get that.
Yes, sir.
Before I deal with it, he can have a seat. Can you call over and get those for me? Have a seat, I'll call it up. Because if they're not going down, he's going right back. Court calls the case, People versus Willie Thorne.
Prosecuting Attorney for the People.
And Alex Warren, Green on behalf of Mr. Thorne. Mr. Thorne, could you please state your name for the court?
Willie Thorne.
Thank you.
Your Honor, I'm asking to adjourn this case so that we can complete discovery and continue our negotiations. I've been in correspondence with the people. They indicate that the outstanding discovery is being sent over to us.
Correct, Your Honor. I created the discovery pack with the meeting notice. It should be sent to the public defender's office within the next day.
January 22nd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
There you go. Red pen.
Thank you, Your Honor.
Thank you, sir. Court calls case, People versus
Add
India
the
Toodle.
.com there, but it'll work.
Alex Warren, Green on behalf of Ms. Tootle.
We're almost ready for lunch break. I've actually got the new portal already set up.
All right, what are we doing?
Your Honor, I'm asking to adjourn this case to continue negotiations with the people.
Probable cause, January 29th, 2026, 9 a.m. bond condition.
Thank you, Your Honor. All right, see you, Andy. I'll be in touch.
Who do we have left?
Court calls case People versus Allen. Try mute.
Alan. Alan, you're up. Wake up, sir.
Yes. Here, sir. Unmute, state your name.
Alan Eugene Tremue Jr.
And Your Honor, we're requesting an adjournment for negotiation on this case, just for further negotiations.
Probable cause conference, January 22nd, 2026, 9 a.m. Bond continue.
You waited 2 hours for that?
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Anthony Walker Ross.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Walker Ross, who should be appearing via Zoom.
Anthony.
Hey.
State your name and get someplace seated.
Anthony Walker Ross.
Your Honor, I just handed you a green sheet to ask for some time for pre-negotiations.
Anthony?
Probable cause conference, January 29th, 2026, 9 a.m. Bond continue.
Thank you. Red, do you need?
Court calls case People versus Willie Wallace.
I can
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Wallace, who should also be appearing via Zoom.
All right, need a camera. What are we doing?
Okay.
We'll be requesting a citizen.
Okay, there we go.
Let me get you an email address.
All right, thank you. What are we doing?
We'll be requesting a set this matter for preliminary exam. To my knowledge, all discovery is complete.
People have their witnesses available the 13th.
Don't see any reason why we would not.
Preliminary examination in person. January 13th, 2026, 9 a.m. That's before 15th District Court, Judge. Bond will continue.
Thank you, Your Honor.
Court calls case of the People versus Ashan Wasim.
Brian Bowling on behalf of Mr. Wasim. Person. State your name for the record, please.
Snow Wasim.
Speak up. You got to.
Snow Wasim.
Can't hear that, Your Honor. Your Honor, we're asking for an adjournment for additional plea discussions with respect to this case.
Probable cause conference will be adjourned. January 22nd, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Thank you.
Have a nice day. Happy New Year. Thank you.
Court calls case People versus Kawan White.
Water Assistant Prosecuting Attorney for the People.
Assistant Public Defender Ben Benoit at Mr. White, who is appearing on Zoom. Mr. White, would you state your name for the record, please?
Juan White.
He's logged in, Your Honor. Can I call him?
I don't know if you can or not, but he needs to be ready to go. Kawan White, prompt him.
Turn on your camera.
Kawan White. I'll pass it. Mr. Weidling, he's lost his privileges. He's not going to be able to appear via Zoom.
Yes, sir.
Court calls the case, People versus Mario Williams.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Williams.
Your name? Mario Williams. Thank you.
Your Honor, we're asking to adjourn this matter for further investigation.
Cause conference, January 15, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you, Your Honor.
Court calls case People versus Xavier Williams.
Overwater Assistant Prosecuting Attorney for the People.
Ashley Bashir on behalf of Xavier Williams, who is approaching.
Xavier Williams.
Thank you.
And Your Honor, we're requesting an adjournment to review discovery that was provided by the prosecutor. I requested it yesterday, and it was provided, so we just need to review.
Probable cause conference, January 22nd, 2026, 9 a.m. Bond continued.
Wow, never had this
Thank
view
you,
of
Your Honor.
dreads before.
Thank you.
We're getting the
Court calls the case People versus Jovial Wilson.
Overwater Assistant Prosecuting Attorney for the People.
Assistant Public Defender Chelsea Virgil with and on behalf of Jovial Wilson.
You started to have it. You were so close.
What was it? What is it?
Jovial Wilson.
Yeah,
Sorry.
I kind of said that.
Yeah, you almost started to have it, then you just let it go. Like, nope.
Wow.
Wow.
That's a bad start.
Come
sir.
up, everybody about their first name swinging. Can't even just name him John. Be over with it. Go ahead.
Hey, at least it wasn't inaccurate, totally wrong.
True. All right.
Your Honor, we are asking for a very brief adjournment. I'm happy to report we do have the media in this case, but Mr. Wilson waited quite a long time for it. We would like to get this case moving along. We're asking you to consider a 1-week adjournment.
1 week.
I think that's enough time for us to review the
The
media.
paperwork for the clerk's office won't try by then.
He's picking up the USB from our office today. I believe in us. We can do this.
Me too. No. She's so nice, though. She is. She always acts so nice and politely. There are people that can take a lesson.
I'm listening.
January 8th,
Your Honor.
2026, 9 a.m. Bond will continue that way. If he can get it done, I don't have to try to mispronounce his name anymore. All right.
Thank you, Your Honor.
Take care. Huh? Okay, I don't know what those are. Court calls the case People versus Stephen. Is it Yenny?
Ashley Feltus for the People.
Assistant Public Defender Chelsea Virgil with and on behalf of Stephen Yaney. Please state your name.
Stephen Yang.
And we are asking to adjourn this for however long the court prefers for media discovery.
So you're looking for more meat. Oh, gosh. Probable cause conference, January 29th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, sir. The facility did. Court does call the case of People versus Robert Watkins.
Ashley Feltus for the People.
And Alex Warren Green on behalf of Mr. Watkins. Your Honor, I don't believe he's present.
He is not. The Jackson County Jail did not sign in if he's still there.
And Your Honor, since the last time his case was scheduled, I did review some records from Jackson County. He has 10 total cases there.
10?
His next court date is February 10th.
Jackson?
That's right. And it looks like what happened is he was transported over there on a couple of cases, and once he arrived, they authorized several other cases.
They've also filed
punched his
F4s on all of them that are felonies.
Yeah,
So-
9 of the 10 are retail fraud first with a habitual fourth, and one of
So you said that the last date of the ones that you see is February 10th?
On the only cases I saw in the circuit court system over there had court dates for February 10th. It looked like they were moving everything to February 10th in front of the Fourth Circuit judge.
Got it. So why don't I try to do this, see if, once they get it settled, we can do this. I'll adjourn this to February 5th, 2026, 9 a.m. That way, maybe we can see if we can get them to appear. Thank you.
Thank you, Your Honor.
Court calls the case People versus Amber Hormos. Recall.
National Feltus with people.
What was I doing?
This is Mr. Mill.
Writing from Jackson.
My apologies, Your Honor.
Pardon?
My apologies, Your Honor. J. Grant Miller, P58658, on behalf of Miss Cormos.
Where is she?
She is still en route, Your Honor.
From Jackson?
Yes, Your Honor.
I called this like.
Believe it was right around 10 o'clock the first time, Your Honor. I could be a little mistaken.
That's okay, even if ballparking it. 2 hours from Jackson?
She had to arrange to get a ride. She does not have her own vehicle.
Bench warrant. No, just kidding.
To bond 10,000 cash surety. Warrant will issue immediately.
Your Honor.
It is a bench warrant. Ooh.
Court calls the case
Sorry,
People
Miss
versus
Jackson.
Mikel Yaquisa. Yeah,
On
Yaquisa.
behalf of the people.
Judy is here.
Is he ready?
Yes, Your Honor, I did speak to him.
Think so?
I spoke.
All right, let's see what
Language.com.
happens.
Mr. Keitha, could you please tell the court your name?
Miguel Urquiza.
And Your Honor, Mr. Keitha would like to address the court.
Go ahead.
So before the 15th, before I got tested, I was invited to a house party or a social gathering with my friends. And that's where I was offered THC, edibles, more like pastries. And I agreed
Brownies.
on taking a chocolate cake, THC, and yeah.
Yeah.
So why did it take all this for you just to say all that?
You're right, and that's my apologies.
No, it's your attempt to try to get.
Your Honor, I think it really comes down to fear and naivety.
Of what?
Naivety.
No, I get that, but
Wow.
I don't know how naive you have to be to come before a judge and just start lying. I don't even get that.
Quite naive, Your Honor.
Quite naive.
He said, who's here with him?
His parents are both here, Your Honor.
Those are his parents?
Yes, Your Honor, I did speak to them in the hallway and I did see them out in the gallery.
Proud as can be.
Proud moment, I'm sure.
Mm-hmm.
Hello, I see. You guys came from Chicago? You kind of heard what he did.
Yeah.
I won't ask Dad. Mom, you want him back? You want him back? You do? Okay, because I don't know what Dad to say. You want him back too? Oh, interesting.
Interesting.
So, young man, I know they didn't teach you to act this way, right? They did not teach you to go around lying about everything. Did they?
Oh, we get a jail food slot feed. Wake up and come to the door. Yeah, I'm giving the mods email addresses for Christmas. Late Christmas present. I haven't given them all out yet. So. You don't need to have one, but if you want one.
Let me just ask you one more question. Prior to you getting locked up, did your parents know you were in trouble?
My father did. My father, he's the one that he attended here before I got locked up.
Reinstate the previous bond, $10,000. Personal recognizance. I'm going to let him go.
Thank you, Your Honor.
Young man, life gets a whole lot easier. It stays a whole lot easier. Just tell the truth. Pay the consequences for what you did and just deal with it. And you don't have to go.
Thank you, Your Honor.
Thank you, sir.
Have a good holiday.
You do the same. Court recalls the case People versus Kawan White.
Assistant Public Defender Ben Denowitz, on behalf of Mr. White, who is on Zoom, would you state your name for the record, Mr. White?
K1 White.
Your Honor, we would like to
welcome
set this
back.
matter for exam.
Discovery is complete.
Yes, Your Honor.
Judge applies a sticker. That's where that's for.
People have their witnesses available on the 13th.
I'm not aware of any conflict, Your Honor.
Preliminary examination in person, January 13th, 2026, 9 a.m. before me.
Before me.
That's in person. Bond will continue. Thank you.
Thank you.
They cannot. Okay, I'll do that in a moment. Court calls the case of the People versus Shing. Oh,
I apologize, Your Honor. May I swear in the name
yes,
of the interpreter?
you may.
Good afternoon, Grace. You're in front of the Honorable Jake Cedric Simpson out of the 14th District Court, Washtenaw County, State of Michigan. Our number two.
I guess we're done. We're done. We're done. We're done. All right. Boom, boom, boom. All right, we're gonna go to lunch. I don't know why. I don't know why they ended right there, but they did. My salads was delicious. I finished it a long time ago. Got a call. Let's see who this is. Hello.
Hi, Dwayne.
Yeah.
Hi, Dwayne. My name is Brandy, and I work in the fulfillment department at Great Vacations. I'm just reaching out about some travel credit on file.
Thanks, Brandy. What's up?
Okay, so it's my job to go through and close out all the expired accounts. But when I saw how much credit you had, I didn't feel comfortable closing out the account without at least touching base with you and seeing if you're interested in traveling.
Oh, I am. I said I am. Brandy, we need to take you back to Sales 101. I was cheerful. I said all the right things. I guess she's used to people saying no. My script only allows for 2 no's and then a yes, not a yes on the first question, apparently. She gone. All right, we're going to go to lunch as well. I was scheduled to come back in at 1:30. We're going to now push it out, get a full hour lunch, if that's all right. No, I need to comb my hair a little different. It's a little poofy back there. We'll just go to this camera. We'll call it like that. Nobody told me my hair is like poofing up. Oh, it's my hairband. Okay, fun fact. I wear these every day I'm live, right? This brand is the only brand of headphones I've ever used on the channel, with the exception of in-ear buds, like for one day. It has a big fat, let me get a demonstration model so I can keep hearing myself and not do it. I have many of them, so I think I have about 7 pairs of these in this office. It has a big fat band across the top, which rests on your hair. It's very comfortable to wear. It doesn't feel like vice grips. Very nice cushions, great sound. I can hear through them, so if people talk to me in the room, it's great. Doesn't block everything out. It's not noise canceling or anything. The downside is can you guys see this? It leaves a dent in my hair right here, right there. It leaves a dent, which trains my hair. So on days, I mean, I can get out of the shower, nice shampoo, conditioner, everything. It still has this thing that happens. I don't know how to fix it. My hair will permanently have this little flip. So, yeah. Anyway, I just thought you shaved your head was shaped that way. All right. Well, it makes it stick up in back and stick up in front and then flat in the middle. Do you ever find the clippers? No, I think Mrs. R.A. had to buy a new set. It has not arrived yet. So haircut soon, maybe next year, whenever the clippers arrive. I don't know if she's bought them yet. I think I saw them in the Amazon cart. But she's got this great pair of clippers that are just they're really good, and she's good at cutting hair. And I'd rather have her do it than anyone at like Great Clips or something else, because basically I get better quality and more consistency when Mrs. R.A. cuts my hair. It's a little different each time, and she experiments here and there, and it's all right. It will grow back for the most part. I'm fortunate enough I'm in a phase of my life where the hair doesn't in fact grow back. That will change in time, I'm sure. But clippers are in the wall. Oh my goodness, purple coconut. That would be funny. But no, I don't. I have not checked this closet. They might be in this closet right here. All right. I do a double take in public if I saw you without the headphones. I wear them around just for that reason. All right, let's go to lunch. We'll be back in an hour. We have a portal set up that'll bring you there. I have to fix it so that it starts at the right time. Some more court hopping as we finish out this year. We've got some big cases coming up that will be a lot of fun. Why can I not get into that? Change the time here. We've got some great cases coming up, so please do stick around and like, subscribe, share this channel with your friends, drag your friends in here, make them watch it as well. It'd be great. We are going to try to grow the channel next year. That's my personal goal. So I will need all your help to do that. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in about an hour. Portal's built, so I'm coming back. Amber do get feeling better. She got the same bug we had in our house. Bad news, Amber. It takes 2 weeks. It's 2 weeks before it's all the way gone. And I'm sorry to be the one to tell you that, but it's worse, and then it's better, and then it gets worse again, and then it gets better. I think that's how it works. So hopefully you're on the getting better for the last time. All right, I think that's it. You guys have a great lunch. We will see you afterwards, and I've got to think over what the mod suggested. Red, you're making a strong argument. I just want to see what impact that would have on the company. All right, you guys are amazing. We'll see you after lunch. Have a good one. Bye-bye.